Lordship. So I'm seeking for an adjournment for today. Lord.
Heard, Miss. What is your name?
P. Thapa,
Engage for the which side?
petitioner,
Petitioner side.
Lord, by the legal aid.
Heard. Miss P. Thapa, learned counsel for the petitioner, who submits that her Mr. S. Datta, learned senior counsel, has been newly engaged in for the petitioner in this case, and therefore she prays for an adjournment on that ground. The prayer is allowed. Let this matter be listed. Motion item
Next week, after 15, Lord.
in the next week.
8, please. Lordship, I beg to mention item number 13, Lordship. Due to my senior's personal difficulties, I want to mention this matter. Item number 13.
13.
13.
Have you informed the other side?
Yes, already.
You are for the petitioner,
For the appellant.
for the appellant. Heard, Miss, what is your name?
And Doctor.
And Datta, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who has no objection to the said prayer, hence the prayer is allowed. Let this matter, hence this prayer is allowed to stop. Bas.
Item number 17. With the consent of other side, we would request for adjournment of the matter.
What is your name?
Arun Kumar Saxena.
What is your name?
Arun Kumar Saxena.
Arun Kumar
Saxena.
Saxena. You are for?
For a petitioner.
Heard, Mr. A.K. Saxena, learned counsel for the petitioner, who prays for adjournment due to personal difficulty of the conducting counsel. He submits that he has informed the learned counsel for the respondent regarding his prayer, who has no objection to this same. Stop. Hence the prayer is allowed.
Wait, Lordship, in item number 36, this IA has been filed for modification or correction of the order. Lordship, may kindly direct to place it before the Honorable Justice P.J. Sekia, because this was passed by the
Okay.
Honorable P.J. Item 36.
Item number 36. Heard, Mr. H. Agarwal, learned counsel for the applicant, who submits that this interlocutory application has been filed praying for rectification of an order passed by a coordinate bench of this court, within bracket Honorable Mr. Justice P.J. Sekia, and therefore prays for listing this matter before appropriate bench. Stop. Registry to verify and list this matter before appropriate bench.
Kindly allow me to tomorrow, Lordship, because there is an urgency in this case. By order, it has come. We have mentioned it, and it has come today also
Okay.
by order.
Tomorrow.
Obliged.
May I please, your Lordship?
That is on
I
the
beg to, may I please, your Lordship? I beg to mention item number 27 for the appellant. The senior engaged counsel could not be present today due to his personal difficulty. I request. your
You have
Lordship may kindly,
informed the other side. Have you informed the other side?
Not yet. I have to inform the other side.
No, you have to inform first. We'll allow your prayer. We'll allow your prayer. You inform the other side first.
Okay, your Lordship. I think the other side.
Other side may not be here in the morning because item is 27. So you have to find out. And
Find out and mention about the matter.
then you come and mention. Then I'll allow.
May I please, your Lordship? Lordship, I beg to mention item number 8, motion matter.
some difficulties, your lordship, the brief is not with me. So can it be listed on 16th of this month?
Okay. Heard Mr. D. Mondal. Item number
8.
8. Your name is not reflected there.
Then?
Item number 8 or 6?
Savitri Deka. 6. I'm sorry.
6. Item number 6. Item number 6. Heard Mr. D. Mondal, learned counsel for the petitioner, who prays for an adjournment on the ground that he is not having the brief of the case today. Stop. Considering the ground, the prayer is allowed. Let this matter be listed on
16th.
16th of December.
Highly obliged.
Lordship, may I like to mention item number 10 for motion. Lordship, my senior has some personal difficulty.
Item number
Lordship,
10. What is your name?
yes, me.
Heard Miss H.K. Sumi, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed on 12th of December.
Lordship.
May I please, your lordship, in item number 14, lordship, I have been instructed to withdraw this matter as already settlement has been made between the parties.
40.
Yes, your lordship. 1-4.
You are for?
Mr.
What is your name? Heard Miss R. Devi, learned counsel, appearing on behalf of Mr. M. Bora, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant transfer petition on the ground that the matter has already been amicably settled between the parties. Considering the submissions made by learned counsel, the prayer is allowed. This transfer petition is dismissed, accordingly dismissed on withdrawal.
Review lordship, in the lower court, the statement of recording of statement of the victim is fixed on 28th of this month, lordship. So may I pray for a date in the next month, lordship, immediately after reopening, lordship.
This is item number?
24.
Yes, Mr. Sharma.
That was exactly my prayer on the last day, Lordship. I had pointed out to your Lordship that the victim has not been examined, but they insisted on fixing
They
it today.
insisted for today.
Yes. Let it be,
Miss,
let it be decided on merits, Lordship. Because they insisted upon their insistence, it was listed there.
Lordship, kindly, lordship, it's fixed on 28th, lordship.
heard Miss, what is your name?
Said lordship.
Zed Anzum, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Miss M. K. Brown, learned amicus curiae, appearing for the respondent number 2. Learned counsel for the petitioner has submitted that the case before the trial court is fixed on
28th of this month.
20th
of
December for examination of the victim girl, and therefore prays for listing this bail application after the said date.
Just one more thing, Lordship, the records, Lordship, it is updated only till 1/11/25, wherein Lordship, the charges were also not fed as per the records, so it needs to be updated.
Okay. It also appears that the scan copy of the trial court records, which is available before this court, is not up to date. And therefore, an up-to-date scan copy of the trial court record may, up-to-date scan copy of the trial court record as on 21/12/2025 may be called for from the trial court. registry to take steps for requisitioning the scanned copy. Let this matter be listed on 6th of January,
Lordship, can it be on 7th, Lordship?
7th of January,
Deeply well, Lordship.
Along with the deposition of witnesses, you can examine.
along with the deposition of scan copy, লগত ৰাখিব, scan copy, along with the scan copy of the deposition of witnesses recorded if any.
Deeply well, Lordship.
Item 41 from supplementary list.
Kindly pass it over for the time being. Madam. Time being. Madam.
Yes,
They are paying for time being. Lordship.
okay. After some time.
But this transfer petition has been filed by the petitioner for transfer of money suit number 96/2024.
Transfer of
Money suit number 96/24, my lord, pending in the court of learned civil judge senior division Dibrugarh, my lord.
what is the ground for transfer?
My lord, first of all, my lord, the agreement was
At what stage it is pending?
for issues, my lord,
Framing of issues.
framing of draft, filing of draft issues, my lord.
You have filed written statement.
I have filed written statement and raised the objection regarding the jurisdiction of my lord, my lord. My lord, may kindly come to page number 15, my lord.
So what was held by the trial court?
Trial court has not decided, my lord, anything, my lord.
Question of jurisdiction has been pleaded in the written statement.
Yes, my lord. My lord, may kindly come to, my lord, page 19, my lord, paragraph 7 of written statement. I have particularly raised that. Page number 19, my lord, paragraph 7. The petitioner wants, my lord, profit sharing, my lord, from an institution which is situated at Guwahati, my lord. Even the agreement for investment was also executed at Guwahati, my lord.
Okay, let us issue notice. Heard, Mr. What is your name?
M.K. Sharma, my lord.
M.K. Sharma.
My
Learned,
signature is on the Wakalatnama, my lord.
okay, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed for praying for transfer of money suit number 96/2024 filed by the respondent before the court of learned civil judge senior division Dibrugarh to the court of competent jurisdiction at Guwahati, Kamrup Metro. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Dream prayer, my lord.
No interim. And this.
Yeah, please.
If this is a transfer application with regards to the matrimonial dispute, the petitioner is the wife. I pray for transfer of FC civil case of Kamrup Metro, Principal Civil Judge 1 to Session Judge Bongaigaon. The wife is a permanent resident of the district Bongaigaon, and the marriage was also solemnized in Bongaigaon. In fact, if my lord peruses annexure number 1, the marriage was also registered in Bongaigaon.
And Why in Guwahati it has been filed?
The,
You stayed,
I stay in
where did you stay together last?
in Azra.
In
That's why
Goa.
the husband had filed the decree for separation in Kamrup Metro, Lordship. But Lordship, let's peruse, we have filed two number of cases against the husband, which is also pending in Bongaigaon, Lordship. Moreover, the wife has no independent source of income. She was a housewife.
What is the stage?
We have not filed the written statement, Lordship.
Okay. Heard Mr. M.
F for it.
F. Faridi, learned counsel for the petitioner. Stop. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner as petitioner Srimati Daisy Das, praying for transfer of FC within bracket civil case number 1187/2025 filed by the respondent, who is her husband, before the Court of Learned Principal Judge Family Court number Family Court number 1, Kamrup Metro, Guwahati, to the Court of Learned District Judge Bongaigaon. Learned counsel for the petitioner has submitted that the marriage between the parties was solemnized at Bongaigaon, and the petitioner, who is the wife, is a resident of Bongaigaon and has no independent source of income of her own. He further submits that the petitioner has also instituted two other cases which are presently pending in the courts at Bongaigaon. So, why it would be difficult on your part?
This because she doesn't have independent source of income. Moreover, no one is there to travel.
He submits that it would be very inconvenient for the petitioner to defend her case, defend the divorce case filed by the husband against her at Guwahati. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Stop. After considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, further proceeding of FC civil case number 1187/2025 is stayed till next returnable date. Please accordingly.
Much of.
May please, your lordship. No, this is civil revision petition, my lord. At this statement, I only pray for issuance of notice, my.
What are you impugning?
Feeling, my lord, the order, my lord, at page number 120, 120, 120, my lord.
What order?
My lord, by the executing court, dismiss our execution case, saying that, my lord, this decree is not enforceable. Basically, my lord, the case is like this, that the plaintiffs,
Okay.
he filed a suit for partition, saying that he is entitled to Schedule A1 land out of Schedule A land. But the Schedule A1 land did not contain any boundaries, because in a partition suit, he cannot give boundaries. He can only say that he is entitled to this much of share. And after the decree is passed, the preliminary decree will be, at the time of preliminary decree, the report will be called for and partition will be done, and then only the boundaries can be ascertained. the law, this executing court now are saying that since the boundaries were not mentioned, so this decree could not be enforced and accordingly dismiss the execution case. Madam.
You have
Whereas
prayed
it-
for the execution of the preliminary decree.
No, execution of the main decree. Because there was no preliminary decree,
If there was no preliminary decree,
but our right was there. The ex parte decree, my lord, the court said that we are entitled to this much of share. So that right will always be there. So it will
but
be,
partition by meets and bounds was not done,
no, not that.
then how it will be executed?
It will be the duty of the executing court because every order of the civil court is enforceable, madam. So,
No, the order must be in a form.
yes, so lordship will
So-
kindly see the order at page number 82. 82. The suit was decreed ex parte.
Okay, we are issuing.
Right.
You could have asked for rectification of the order.
Yes, that could have been done.
Heard Mr. S. Das, learned counsel for the petitioner. This application under section 115 of the Code of Civil Procedure 1908 has been filed by the petitioner impugning the order dated 19/9/2025 passed by the Court of Learned Civil Judge Junior Division Bajali at Pathshala in title execution case number 2022. Title execution case number 1 of 2022. Stop, issue notice to the respondents. And records would be
Yes,
necessary
of the execution case.
and call for the case record of the title execution case number 1/2022. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Highly obliged.
Item 4.
Lordship, this is a civil division. Expiry order dated on 18/4/2024 in title suit case number, your lordship, 121 on continuation of delay. And we have filed a miss case, J case number 59/2025 in the civil judge junior division Bilasipara, your lordship, and that have been rejected. The order have been which has been passed by this learned trial court. Page of your lordship, page 14 starts.
Oh,
Yeah.
your delay was not condoned.
Not condoned. Since I'm a wage labor, I went to Chennai for my livelihood.
Okay,
Accordingly,
we'll issue notice. Heard Dr. B. N. Gogoi, learned counsel for the petitioner. This application under section 115/115 of the Code of Civil Procedure 1908 has been filed by the petitioner Shri Sattar Khan impugning the order dated 6/8/2025 passed in Miss J case number 59/2025, where the Court of London, whereby the Court of London Civil Judge Junior Division number 2, Bilasipara, had rejected the prayer for condonation of delay in filing the application for vacating the ex parte order dated 18/4/2025 in title suit number 121/2023. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by registered post with AD as well as by speed post, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Deeply obliged.
Right, please, Lord. My lord, in this case, my lord, the petitioner is a degree holder, my lord. He filed title execution of 2006, my lord. The long pending title execution. Now, my lord, two mistakes has been filed, my lord. One under section 97, third party petition, and one for completing them in the execution process. And your lordship will find page 69, my lord. The learned executing court has paid the title execution. Oh, my lord, my prayer is very limited, my lord. My lord, this matter may be disposed of directing the executing court to dispose the connected miscase, my lord, as early as possible, my lord. Otherwise, my lord, my execution, it is already a long pending execution. And since 9/4/2024, my lord, execution is late, my lord.
When these miscases were filed,
Just before passing this order, my lord.
when?
My lord, one was filed, my lord.
Sir, 4.
4 and 5. my lord.
In the month of April. Yes, anything.
This case has been lordship, after notice was, I think,
My lord, if
completed.
notice is, my lord, issued, my lord, then.
And there is a
execution will-
private dispute lordship that the parties lordship.
This correct, my lord. My prayer is very limited, my lord. If connected miscases are disposed of as early as possible, my lord, my execution will be start, my lord.
No, have you made any such prayer before the trial court? Which orders you are impugning in this?
I issued the stay order, my lord. Now, my lord, I have, my lord, confined my prayer to that extent.
Okay. Heard Mr.
H.M.R. Chaudhary.
A.
H.M.R. Chaudhary.
A.H.M.R. Chaudhary, learned counsel for the petitioner. Also heard Miss D.D. Burman, learned senior additional government advocate, appearing for respondent number 1, 2, and 3. 1, 2, and 3. This one state of Assam. 1, 2, and 3. We are disposing of this. This interlocutory application has been filed by the petitioner Muziruddin under Article 227 of the Constitution of India, impugning the order dated 9/4/2025 passed by the Court of London, Civil Judge within bracket Senior Division, Shri Bhumi, in title execution case number 6/2025, whereby the executing court had stayed the execution case till the disposal of Miss Case number 53/2025 and Miss Case number 43/2025. Stop. Learned counsel for the petitioner has submitted that Miss Case number 53/2025 has submitted that the petitioner is the decree holder in title suit number 1/2001 and has filed an execution case which was registered as title execution case number 6/2006 and has been pending for execution for almost 19 years. In the meanwhile, the on whose application Miss Case 53 was registered,
Third party,
Who is that party?
My lord. They are third party claim, my lord. 53.
Third party, but who is that party? Which opposite party?
Opposite party, my lord, opposite party number 42, my lord. 4241.
ये लिख ले last. In the meanwhile, the respondent number 4 to 41 have filed an application for impleading them in
No, no, this is not.
application under order 21 rule 97 of the Code of Civil Procedure, as well as another miss case, that is 43 of 2025 was filed by whom? Same.
My lord, 53 was by, 53 was by the, under order 10 rule 10 2, my lord, by respondent number 42 and 43. And 53 was, 43 was by the third party, my lord.
Katu. Learned counsel for the petitioner has submitted that on application under order 1 rule 10 of the Code of Civil Procedure filed by respondent number 42 and 43, a miss case, that is miss case being miss case number 53/2025 was registered. Further, on the basis of an application under order 21 rule 97 filed by respondent number 4 to 41, miss case number 43/2025 has been registered. He submits that though the impugn order has been passed in the month of April this year, however, the aforesaid miscases are not yet disposed of. He submits that though the petitioner has impugned the order dated 9/4/2025 passed in title execution case number 6/2006. However, the petitioner is limiting his prayer to the extent of issuance of a direction to the executing court to dispose of the miss case number 53/2025 and miss case number 43/2025 as early as possible. Stop. Considering the submissions made by learned counsel for the petitioner, as well as considering the fact that the title execution case number 6/2006 is pending for more than 19 years, this civil revision petition is disposed of with a direction to the executing court, that is the Court of Learned Civil Judge Senior Division Sri Bhumi, to make all endeavors to dispose of miss case number 53/2025 as well as miss case number 43/2025 as expeditiously as possible. Let a copy of this order be furnished to the executing court by the,
Outer limit, my lord.
yes,
Outer limit, my lord.
no outer limit. As expeditiously as possible. We don't know the pendency of that court.
Item 7. Oblige.
Please, Your Lordship. This is a civil revision petition against the order dated 11/9/25, Annexure A, whereby appeal of the petitioner was dismissed. At this stage, notice may be issued.
You were plaintiff or defendant.
Defendant.
What is your name?
Ardora.
R?
Dwara.
Heard Mr. R. Dwara. Learned counsel for the petitioner. This interlocutory application under Article 227 of the Constitution of India has been filed by the petitioners impugning the judgment and order dated 11/9/2025 passed by the Court of Learned Civil Judge Senior Division, Kamrup, Amingaon, in Miss Appeal number 10/2024, whereby the appeal filed by the present petitioners was dismissed. Issue notice to the respondent and call for the records of the Miss Appeal case number 10/2024 from the Court of Learned Civil Judge Senior Division, Kamrup, Amingaon. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
Please, Your Lordship. The prisoner before Lordship, my lord, they had a legal heir of late Budhiram Nath Bora, my lord. And whereas defendant number 1, my lord, happens to be one of the legal heirs. What happened, my lord, in the year 22, my lord, for purpose of mutation, my lord, they obtained signatures of the defendant, of the plaintiff, and for purpose of retaining their name, my lord. Now, subsequently, in 2025, when we found that the vacant lands, the building has been constructed, my lord, then we found that they have already mutated his only name, and he got it partitioned. A separate pata has been issued, my lord, and started construction. And accordingly, file a suit, that is your lawful file as page 15, the title suit, my lord. And the title suit, my lord, we have paid for declaring that the page 23 is the prayer portion, my lord. That declaring the plaintiff along with defendant having the legal rights of inheritance over the properties left by deceased Budinath Bora for movable immovable properties A and B. Decree declaring the plaintiff and defendant have right, title, interest to the suit and A and B. Cast position of the share of the plaintiff suit by and also by removing all the permanent structure. And E is important. Decree declaring the mutation orders dated 35/2022 passed by the learned circle officer respect of schedule A land and went through under revenue circle, granting in favor of without meeting the names of plaintiff by immediate void and so and declaring the partition order in respect of partition case number so and so, respectively in respect of suit number so and so, suit pata number so and so as void and such should be decreed for cancellation of aforesaid partition orders. So now immediately after filing of this petition, my lord, a injunction order was granted in my favor. That you will also find that injunction order is that page. That is page 71. My. This order dated 29/3/2005. There you will also find that he has the learned, the Honorable Court, my lord, has averments and the plate has been reiterated, my lord. Then your lordship may kindly come to page 73, the finding part, my lord. As evident from the pleadings, number 4, paragraph 4, my lord, that the opposite party has started the construction of the by meeting his name in place of the supervisor. In the circumstances, if petitioners can eventually prove the rightful claim of the suit claim. In the meantime, if opposite party is not restrained from construction, it will lead to a changing of nature of the suit claim. As such, opposite party is not restrained, will cause irreparable loss and injury to the petitioners, also lead to contestability of proceeding. In my humble opinion, it is important to restrain opposite party by making any further changes over the suit land or from alienating the suit land in any manner. Considering the matter in entirety, I am of the view that very purpose of granting injunction be defeated if the prayer for arranging terms and paid for is not allowed at this stage. As an intermission is paid for, petitioner is not allowed at stage, and then it is passed against the opposite party, restraining him in his agents, labors Manson legal representatives from making any permanent temporary construction of the suit land, schedule A and B, from transferring or alienating suit land so and so in a manner till the next date fix, and so and so. Now, that order was subsequently the opposite party, my lord, they filed their written statement, and but on 31/5, that page 82, my lord, that is
Okay.
the absolute order,
Page
82. The written order has been passed, my lord, on 31/5/2012. Today is fixed for hearing a necessary order. Learned counsel for the petitioner submitted, the opposite party has wrongfully entered his name in the record of right of suit land. He further referred to NOC furnished by the opposite party number dated 3320, when only one partner number and DAC number is mentioned, stated that document is self-explanatory to the extent that NOC was not respect to the whole suit land. So they are stated about the NOC, it amounts to no whole total, only schedule A land. He further submitted, even for argument's sake, it is supposed that both the petitioners have given NOC is not admissible in law, in much as under section 17(1) small b of the Registration Act, which mandate that a document by which a person is relinquished his share should be compulsorily registered. He submitted even arguments placed on the previous date may be considered, and interim order may be absolute. And he further stated the offer of the opposite party that he will give an undertaking that he will give that entitled share to both the petitioners after his house constructed is over, is not a viable solution. So he wants to make that only in respect to other share also I will make construction. After completion, I will give your share now. That oral submission has been made. Learning on the opposite party submitted, if any intervention is made absolute, in such as opposite party will suffer irreparable loss because the housing loan already been disbursed in one part. Yet the opposite party ready to give undertaking by promising that upon completion of construction of the house, Suitland as will give a legitimate share of both the petitions. Upon hearing the views perusal of the case, I am on view the primacy case is favor of the petition as opposite party at least has failed to satisfy that duly exonerated was given to him by the petitioner, allowing him to record his full name with respect to suit land. With respect to the factor of irreparable loss in which evident the opposite party has obtained housing loan for construction or suit land, there is no denying fact that he shall suffer loss. However, on weighing the contents of both sides, this is the balance of convenience. It is also safe on presume that it will be a petitioner who will suffer better loss, injury if any term is not vacated, is vacated. Further, such construction is continued to be allowed over a disputed suit land, they will change the nature and structure of the suit land, which shall obstruct the rightful adjudication of the case. Further, in respect of factor of balance of convenience, thinks that by refusing the continuation of injunction order, greater inconvenience will cause to the plaintiff. Thus, in view of the fact, I deem it fit to make the absolute relief to the interim and so, his legal agent so and so, represented by making a permanent temporary injunction over the suit land, schedule A and B, also transferring all any so and so. So that order was under challenge before the district judge by way of appeal, misappeal. And civil judge senior division, madam, by judgment and order dated that your lordship pays 92, madam, which is under challenge before this honorable court, madam. Now this 92, I am not reading the whole part, madam. Relevant portion I am coming to it, madam. The lordship may kindly come. Then page 98 is the point of determination. This point of discussion decision. Then the respondent's averment during the lifetime of the plaintiff, he used to say that all his lands buildings were equally disturbing so and so. Is averment denied by the appellate. Paragraph 7 is denied that so and so. That part can be left over, my his pleadings. Then paragraph 15. As per the pleadings of the parties, name of the defendant was mutually respect of suit land by order dated 35. As per the page 81 of C2 file of the plaintiff deposited land revenue on 23/12/21, it has been declared till the period to 21/22. Plaintiffs have not produced any document or deposit of land revenue after 23/12/21 or after 35/22, that is post mutation of defendant's name. Plaintiff have not established the balance of convenience for granting injunction waived in their favor. Plaintiff have no averment as how inconvenience will cause to them if their son and brother is not restrained from constructing a new building on vacant land. Fact that mutation of land aspect of suit land on 35/22 partition as well the defendant of the permission building house of the suit land. According to plaintiff, they came to know about the initiation of construction building suit land only on 17/3/2025. As they themselves saw it, defendants after obtaining the loan has started construction of building of suit land. It appeared that the case recorded there was no partition of any of the SSL properties of even prior to the said mutation of defendant's name. Question of entitlement of share of the plaintiff suit land is a matter to be adjudicated on the basis of the evidence adduced by the parties. So there is a finding my lord has a similar finding by the trial court also. And this is not a suit of partition. There is no pleading that plaintiffs have approached any higher revenue authority against the mutation order, but we have challenged the mutation order. Question of filing if that's a record of 22 my lord. So we are
No,
filing
you have not challenged it before.
revenue order. That's because
Revenue.
we come to know on 25 only. That's why after going through the records. So and so, then he relied upon the decision of so and so. The report in AR 2000 Punjab and Haryana, the remedy of a co-owner not in position, share of so and so, the joint property by a suit for partition actual, but not for ejectment. In this case, suit is land according to plaintiff is a vacant land. Fact is the plaintiff is living in their own house, even if defendants constitute the construction of the suit land. And suit land is likely to be partition in any event or being approached by either party. Risks of losing the construction cost is upon defendant. Plaintiffs have not said how they will incur irreparable loss if the defendant completes the construction. Even if we assume is a co-sharer in the respect of suit land, he cannot be restrained from constructing a building or suit land. The plaintiff has failed to establish they will suffer irreparable loss if temporary injunction is not granted as prayed for. Plaintiff has no averment that defendant has made any attempt to trespass a suit land. The suit land is owned by predecessor interests of the parties, and the disputed fact that defendant has got his sale name in the sole name in the mutated in the name of so and so as per NOC given. As per the entire discussion, court arrives at the conclusion that plaintiff is not to be entitled for grant of temporary injunction. Result appeal is allowed. Impugn order is so and so. There is no order. However, your lordship, last time is very important. If the defendant raises completely constructs any construction, he removed that construction without a remove. If the portion of the house is constructed by falls in the share of either of the plaintiffs. So now the appellate court one, how can he build up a new case, my your lordship may kindly say. When he knows that the other portion he does is not entitled. There was no partition as such. The whole plot has been constructed now. He said, after construction, they will give me share. Whether that is permissible, my lord. When I have challenged the whole partition order as well as the mutation order. And injunction was granted, the reason order has been passed. Simply on the ground that
Defendant number one is your son.
is my son and brother.
Son and one is,
One is the son as well as the elder brother of the, because plaintiff one is the mother and sister of this
so son has mutated the
whole plot of land,
father's property, entire property.
entire property. Illegally, man. And it was not only he mutated, but he got it partitioned separately, which is not permissible under law. Because under Transport Property Act, that there has to be registration deed, my even if regarding sale of my share of my that has not
No,
been.
there may be family arrangement which.
That there is no family arrangement, nothing agreement was been executed, my. Now he
there-
says that other portion I will give to him, my lord, after construction. How did it possible, my lord?
There
when-
can be oral family arrangement.
But oral that is not there, my lord. He says that later on, during the argument, course of argument, he is making a pleading, my lord. And the learned appellate court, my lord. On hearing, my lord, they had found that yes, since he will give the other portion to him, so injunction may be vacated. But that it cannot be done. And had there been a written agreement between the parties, mutual settlement matter would have been different, my. Now out of nowhere, my lord, since-
Okay, we'll issue notice.
status quo may be maintained, my lord. Otherwise, it will create problem, my lord. Because my whole suit will be in flux first.
Heard Mr. P. Kotoki, learned counsel for the petitioners. Also heard Ms. D.D. Burman, learned senior additional government advocate appearing for respondent number 2 and 3. This interlocutory application under Article 227 of the Constitution of India has been filed by the petitioners impugning the judgment and order dated 26/9/2025 passed by the Court of London, Civil Judge, Senior Division, Sibsagar in Miss Appeal number 6/2025, whereby the head interim, whereby the temporary injunction granted against respondent number 1 by the trial court was vacated. Learned Counsel for the petitioner submits that the petitioners are the legal heir of late Budindranath Bora, and the respondent number 1 is the son of petitioner number 1 as well as brother of petitioner number 2. Stop. He submits that the respondent number 1, after death of her father, had mutated his name in respect of the how much land?
You can tell me how much damage is that is in the plain 1.5 quota, my lord.
In respect of a plot of land
1.7 quota. That's basically
measuring 1 kotha 7 lechas, which belonged to the predecessor and interest of the present petitioners. Learned Counsel for the petitioner submits that the mutation was obtained on the basis of a purported NOC granted by the present petition. You have issued any NOC?
No, but blank signature was taken for because there's another land, ancestral land,
Okay,
for mutating that land. That was mutated.
stop. Learned Counsel for the petitioner submits that the signatures of the present petitioners were obtained by the respondent number 1, who is the son of petitioner number 1 and brother of petitioner number 2, on the pretext that said signatures were required in respect of mutating their name in connection with some other land of their deceased late Budindranath Bora. Stop. However, the said signatures were used to manufacture an NOC, which was later on used for mutating the name of respondent number 1 in respect of the suit land. Further, after mutating the name, his name, the respondent number 4 also got the land partition and obtained a patta from the revenue authorities in his name. Stop. Learned Counsel for the petitioner further submits that the petitioner came to know about this fact only in the month of, when you came to know?
The month of March, my lord.
In the month of March 2025, and thereafter immediately on 28 March 2025, they instituted a title suit which was registered as title suit number 21/2025. Before the Court of Learned Civil Judge Junior Division at Sibsagar, praying for
That you'll base for 24, man. 20.
praying for declaratory reliefs as well as praying for cancellation of the mutation order as well and declaring that the partition order obtained by the respondent number 1 in respect of the suit land as void. In the aforesaid title suit, the present petitioner had also prayed for grant of temporary injunction by filing a miscase. And in the said miscase, by order dated
Order dated 29/3, man. Initial order,
29/3,
20,
2025,
Yes, 70.
the trial court granted aid interim injunction in favor of the present petitioner, restraining the present respondent number 1 from continuing the construction over the suit land. Later on, the said interim injunction was made absolute by the trial court
82, 31/5/2005. 20.
by its order dated 31/5/2025, passed in Ms. J case number 38/2025. Stop. On being aggrieved with the aforesaid order, the respondent number 1 preferred an appeal under Order 43, Rule 1, within bracket small r of the Code of Civil Procedure before the Court of Learned Civil Judge Senior Division, Sibsagar. And the court of by the impugned judgment and order dated 26/9/2025, this appellate court vacated the temporary injunction order dated 31/5/2025 by the trial court in Ms. J case number 38/2025. Learned counsel for the petitioner has submitted that in the impugned order itself, the appellate court has admitted that the question of entitlement of the shares of the present petitioners over suit land is a matter to be adjudicated on the basis of evidence adduced by the parties. However, in spite of that, it vacated the injunction order dated, temporary injunction order dated 31/5/2025. by making an observation that if the respondent completes the construction he may have to remove the portion of the house, remove that portion of the house which would ultimately, that portion of the house, if same is found to be in the share of the either of the plaintiffs, learned counsel for the petitioner submits that this is a contrary observation made by the appellate court while vacating the injunction order. He submits that if the construction of the house by the son of the petitioner number 1 and brother of the petitioner number 2 over the suit land over which the present petitioner also have shares as ancestral property, is allowed, it would change the nature and character of the suit land. Stop. Issue notice to the respondent. Since Ms. D.D. Burman has appeared for the Ms. D.D. Burman, learned senior additional government advocate is appearing for respondent number 1, 2, and 3. No formal notice need to be issued to the said respondent. However, as regards respondent number 1, the petitioner shall take steps for issuance of notice upon the said respondent by speed post within 3 days from the date of this order, returnable on 6th of January 2025. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, the respondent number 1 is directed to maintain status quo in respect of this suit land till next returnable date, list accordingly.
May I please, Your Lordship? This is a petition, application for setting aside the order dated 28/8/25 passed down by petition number 792/25 entitled suit matrimonial case number 69/25, whereby the prayer for seeking some more time to file written statement was rejected and directed the case shall proceed against the ex parte against the respondent, which is the petitioner in this application. Lordship. Lordship, there was a talk of compromises going on between the parties, and on 21/8/25, the engaged counsel for both the parties were appeared before the trial court and submitted verbally that there was a talk of compromises going on, and they need some time to, and accordingly the adjournment was allowed. But till the next date, they did not come to any conclusion yet. Therefore, the petitioner again filed a petition for adjournment by citing the same ground, but unfortunately, which was rejected, and the Honorable Trial Court passed an order, ex parte order against the petitioner.
Now, what is to be done?
Lordship?
What is to be done?
Lordship, the set aside the order dated 28/8/25 and allow the.
90 days have already been lapsed.
Yes, Lordship.
Since the receipt of summons by you 90 days have lapsed.
Yes, Lordship.
So that limitation
Yes.
is applicable to you also, even if talk of compromises.
Since this matter is matrimonial and between husband and wife, the court can be a considerable
Your wife or husband,
husband.
your wife filed the divorce suit.
Yes.
Okay. You pay a fine to your wife,
There is no
cause.
maintenance case, Lordship, yet.
No, we will set aside this order. You pay 5,000 to your wife. Heard Miss, what is her name?
Yes.
Heard Miss A. Das, learned counsel for the applicant. And learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner Swarna Kamal Roy, alias Swarna Kamal Roy, impugning the order dated 28/8/2025, passed by the Court of London, District Judge Sonitpur in title suit matrimonial, title suit within bracket M, case number 69/2025, whereby the prayer for grant of further time for filing of written statement by the present petitioner was rejected, and the suit was directed to proceed ex parte against the respondent. Learned counsel for the petitioner has submitted that the petitioner is the husband of the respondent. Stop. She further submits that the respondent has filed a suit for divorce, which was registered suit for divorce before the Court of London, District Judge Sonitpur, which was registered as title suit number title suit within bracket M, case number 69/2025. She submits that as the petitioner and the respondent are related to each other as husband and wife, there was a talk of compromise going on between both the parties, and therefore there was delay in filing of the written statement. She submits that, however, the trial court, ignoring this aspect, that the suit before the court was a matrimonial suit, strictly construed the provisions of Order 8, Rule 1, and fixed the case for ex parte hearing against the petitioner, in spite of the fact that it was pleaded by the petitioner before the court that a talk of compromise was going on between the parties. The learned counsel for the petitioner submits that in matrimonial suit, the court ought to have given time to the petitioner or no, learned counsel for the petitioner submits that the court ought to have given extended time to the petitioner beyond the period of 90 days, considering the fact that the suit between the parties is a matrimonial suit and a talk of compromise was going on between the parties. She submits that now the petitioner is ready to file the written statement on any date directed by the court on any terms and conditions. When is the case fixed next? Can you file the written statement tomorrow? He further submits that the title suit matrimonial case number 69/2025 is fixed before the trial court tomorrow, that is on 11th of December 2025. And she is willing and ready to, and the petitioner is willing and ready to file written statement tomorrow itself, subject to any condition imposed by the court. Stop. Stop. Though Order 8 Rule 1 prescribes it time limit for filing of written statement by the respondent, by the defendant within 90 days of receipt of summons by the defendant, however, the time limit so prescribed is not an absolute limit, absolute outer limit. Stop. More so in matrimonial cases. Stop. Under Order 32A within bracket 3 of the Code of Civil Procedure, it is incumbent on the court to try, in cases involving family disputes, to make endeavors so that party reaches an amicable settlement amongst themselves. Hence, this court is of considered opinion that the ground for failing to file written statement by the husband within 90 days of within prescribed period of 90 days ought not to have been strictly, or ought not to have been brushed aside totally by the trial court. And an opportunity ought to have been given to the present petitioner to file the written statement. As the petitioner is ready to abide by any condition, this court is of considered opinion that the interest of the ends of justice would be served if the petitioner is allowed to file written statement in that case, in the aforesaid matrimonial case. Hence, the petitioner is allowed to file written statement in TS within bracket M case number 69/2025 tomorrow, that is on 11th of December 2025, before the trial court, subject to payment of a cost of ₹5,000. Stop. It is made clear that payment of cost shall be a condition precedent before acceptance of the said written statement by the trial court. The cost, if deposited, shall be paid to the respondent wife. this civil division petition is accordingly disposed of without issuing notice to the respondent side. So we should upload this order today itself.
My lord, this revision has been filed challenging the writ issued at page 73 by the Alliance Civil Judge Senior Division Judge Court, whereby he has asked to realize the amount 12,36,000. What happened in the appellate court, the amount was reduced by a decree. But this amount shown to be realized is the amount of the trial court decree. And we have prayed before the trial court to correct that thing, but they are avoiding or ignoring, they are not doing that thing. As a result,
Where is the writ?
yes,
Page number?
trial court decree 17,
Page number?
73. Next are 7. It is
12,36,000.
yes. But this is the amount calculated on the basis of execution petition by the respondent, which is as per trial court decree. And that trial court decree on appeal that was modified by the appellate court. In modification, the amount comes to be about 9 lakhs.
Where is that order?
Yes. Appellate decree, your lordship 58 page, annexure 2. The respondent plaintiff is not entitled to recovery of rent from the month of January 15 to December 17 at the rate of rupees 11,000 per month in view of finding of this court, means appellate court, in issue number 345, and also entitled to enhanced rate at rupees 12,000 per month from May 2018 till recovery of the suit premises. Suit premises has already been vacated by me on 30/11/2023 because there is a concurrent finding of both the court, trial court as well as appellate court. With due regards and obey, I have vacated that. But the amount which they have shown, there is a dispute which matter was brought to the notice of the executing court, but they are not doing anything, only according to the trial court decree amount they have calculated, they are issuing this process. And the trial court decree is also, your lordship may see at page 17.
Page number
19, my lord, sorry.
19.
One.
19 is the
Order, and 33, it is declared that plaintiff is entitled, it is trial court, page 33. Page 33 and 37 also in decree. And this is the handwritten, that was typed written order of the judgment, 33, it is clear. It is declared plaintiff is entitled for recovery of possession of the suit premises by evicting the defendant with her man, agent, border, all these things, and recovery of land due from January 15 to December 17 at rupees 11. This is the trial court decree. The plaintiff is also entitled to enhancement at rupees 12,000 per month from May 2018 till.
No, where is the calculation? How it came to the extent of 12,36,000? Where is the calculation breakup?
That backup I have given in my revision petition in page 5 to.
No, how the Court of Civil Justice Senior Division Tejpur calculated the amount?
That is the thing, because on the, I think, on the basis of the revision petition, they have filed.
So have you made any objection
Yes. In,
before the executive
yes.
court?
Yes, my lord. In annexure 5, page 64 and 70. But they are not putting any heat. Sixty-four to 70. I have made a detailed petition.
Whether any order has been passed?
No, that is the thing, but they are issuing the process on the amount, on the basis of the decree of the trial court. It is a settled principle, when there is a appellate decree is to be executed.
And as per appellate court's direction, how much amount according to you?
9,08,500.
Where is the computation, calculation?
I have calculated in the page 5 to 9 of the revision petition. 11 more particularly, page 10. 9, 10, 5. Appellate decree as well as trial court decree.
Okay. Heard Miss Dr. P.C. Majumdar, Lenin. Senior, you are senior counsel? Learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner Srimati Luna Kalita, impugning the issuance of writ dated 5/6/2025 passed by the Court of London Civil Justice Senior Division. Which is the trial court?
Senior division.
Which
Division.
appellate court is the district judge's court,
Exact. Appellate court is
issued by the Court of London Civil Justice Senior Division, Sonitpur, in title execution case number 11/2022. Learned counsel for the petitioner has submitted that the respondents had instituted a title suit being title suit number 5/2018 before the Court of Learned Civil Judge Tejpur, and in the said suit was decreed by the judgment and decree dated 31/5/2023, whereby the
excuse me, 31/5/22.
31/5/2022, whereby the plaintiff was found entitled to the relief of recovery of possession of the suit premises by evicting the defendant within bracket present petitioner and for recovery of rent due from the month of January 2015 to December 2017 at the rate of 11,000 per month and at the rate of 12,000 per and from the month of May 2018 till recovery of the suit premises at the rate of 12,000 per month. Stop. Learned counsel for the petitioner has submitted that the aforesaid judgment and decree of the trial court was challenged by the present petitioner by preferring an appeal which was registered as title appeal number 1/2022 before the Court of London, District Judge Sonitpur. He submits that the appellate court, while upholding the decree regarding eviction of the present petitioner from the suit premises, had made modifications regarding the portion of the trial court's judgment whereby the realization of rent for the suit premises was directed. He submits that by the judgment and decree of the appellate court, it was held that the plaintiff was not entitled to recovery of rent from the month of January 2015 to December 2015 at the rate of 11,000 per month. Further, it was also held by the appellate court that the plaintiff is also not entitled to get an enhanced rent at the rate of 12,000 per month from the month of May 2018 till recovery of the suit premises. It was held by the appellate court that the plaintiff was only entitled to recovery of rent at the rate of 11,000 per month from 12/7/2015 till realization and not before the said date. Learned counsel for the petitioner has submitted that this fact was brought to the notice of the executing court by the present petitioner by filing an application. Where is your application?
Yes, at page 64, my lord.
By filing an application on on 14/7/2023. However, he submits that no order. However, he submits that trial court did not consider the said application and issued the impugned writ for realization of rent of the suit premises to the tune of rupees 12,36,000. He submits that the computation of the outstanding rent made by the executing court is on the basis of the trial court order, and it has not taken into consideration the modification and alteration made regarding the rent to which the respondents / decree holder are entitled to. Learned counsel for the petitioner submits that if the modification made by the appellate court in the trial court's decree is taken into consideration, the outstanding rent to which the judgment debtor would be entitled comes to the tune of rupees, where is the calculation? 9 lakhs.
9,08,000.
Where is that calculation? Page number? Where have you calculated?
I have given in page
Page number?
10. Page right from 9 last.
Comes to Kiasil last line. To the tune of 9 lakh rupees, 9 lakh 8,500 only. And not rupees 12,36,000 as shown in the impugned writ issued by the executing court. Stop. Issue notice to the respondent. Issue notice to the respondent
Meanwhile, there may be interim.
and call for the scanned copy of the records of title execution case number 11/2022. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 3 days from the date of this order, returnable on 8th of January 2025. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, as well as contentions raised by him, you have handed over the
Yes,
eviction
it is-
Ekline Uparot Dibo. Learned counsel for the petitioner has submitted that in the
On 30 November 2023.
in the meanwhile, on 30 November 2023, the petitioner has already vacated the suit premises. Tarpisot last line ki asil. The execution, the further proceeding of title execution case number 11/2022 is stayed till next returnable date. List accordingly.
I think I said 41.
My lord. This case, my lord, I was an interim. If you love to go to the page is order dated 15/10/25. Lordship goes to order dated 15/10/25. Order sheet, my lord.
There's 15,
Date,
there is an order dated 14/10/20.
10/25. Where I was,
Yes.
yes, where I was granted interim bail because of hernia operation. And I have been directed to file an affidavit before this court intervened court regarding compliance with the conditions. So I've already filed the affidavit. And after that, some complication had arisen. Some complication had arisen, so I need further treatment. Actually, the doctor has advised for further post-operation, the first post treatment going on. So because of that, the coordinate bench, okay, this another court, coordinate bench in another case has extended my interim bail. Accordingly, I filed the application
Other case,
in other case, in other court,
in other,
because there are 2-3 cases are there.
okay,
So in
on
other,
the same ground.
not same, but different, but medical ground, But
In
maybe-
that case also you were on interim bail. What is the case here?
here, page pilot FIR, page 7. It is respectfully submitted that one Dharmeshwar Rai, son of Jagat Dipen Roy, resident of village Dharapur, Chareli, has taken my vehicle being Swift Desire and so on rent on last 18/11/24 for period of 11 months. After 5-6 days, he told me that the
No, interim bail is extended till tomorrow, till day after tomorrow. We'll extend it till day after tomorrow.
Why not we can extend it, madam? But thing is that he can dispose also, madam.
Making it absolute.
Taking it absolute, my lord. Because already custody period is over, my lord.
No, you were not in custody.
If you go through a definition of constructive custody, I'm in custody. And even then,
No,
if
you are
do-
not in custody.
Also, the custody period is already 52 days was already over at the time of my release. 52 days was already over. And the section there which have been quoted here, 318, 316, that is 433, 420. Two sections cannot be applied together. Who cannot go together hand in hand. And 111 section is added.
Okay, what is the offense here? Let us.
Page 11, my lord.
Page?
Page 11. It is expressly submitted to one Dharmeshwar Rai, son of Jagat Rai. Page 11.
Yes.
It is expressly submitted that one Dharmeshwar Rai, son of Jagat Dipen Rai, resident of village Dharapur, Charli, has taken my vehicle being suite number so and so on rent on last 18/11/24 for period of 11 months. After 5-6 days, he told me that the vehicle is old and does not gather speed beyond 80 km/h. After that, he told me to provide a new Innova. In this way, he took an amount of 1,30,000 from me. He also took an amount of 4,65,000 from one Montu Bormon for providing a Swift Desire vehicle. Apart from that, he took an amount of 20,000 from our Hoster Das for providing Innova vehicle. He also made an agreement with one Hiranda Bormon in connection with renting of Innova for a period of 11 months. But after that, he did not pay 2 months rent of ₹50,000. I came to know that Dharmeshwar has cheated for 4 of us and misappropriated our money. It is therefore paid to kindly take necessary action in this regard. So in this way, if you also go through that, it's a kind of civil nature case. And at the same time, if you also go through that allegation also, that so and so other party has laws and they have also cheated 4%. The other person has not cheated, they have not lost any FIR. So with the lordship, 111 will attract or not, that has to see, because it's not an organized crime. In that case, my lord, my submission rate let it bail be actually because other two cases are already there. And already 50 days in custody.
How many days you were behind the bars,
Yes.
excluding this interim period? Yes, Mr. He was behind the bar for 52 days.
Lordship.
And whether 111 will come, how? Is any charge sheet has been filed?
Charge does not file, is still under investigation. The first point, Lordship, is Lordship will have to see, he has 12 cases registered against him altogether, right
Yes.
now. And all these cases, modus operandi is the same, exactly the same, whereby Lordship vehicles are taken, then it is sold off, money has been taken, not returned. In this case also, Lordship will see, the vehicle, it has not been recovered till date. And Lordship, the investigation so far has revealed, Lordship, he took bail in the medical ground, that's a different aspect, Lordship. But Lordship, regarding the organized crime, Lordship will see from their possession, Lordship, around 6 or 7 vehicles have been found. And
BMS. BMS. Yes.
And Lordship, the wife of the petitioner, Lordship, she is also in co-accused, Lordship. Investigation was done in respect of her. She was also under interim protection, Lordship. There, Lordship, her bank account has revealed a balance of more than 1 crore rupees, 1 crore rupees, Lordship, which was deposited in her account through cash, Lordship. And all those are unaccounted amount, Lordship, because she is not employed anywhere, Lordship. So investigation in that regard is also going on. From their position, Lordship, around 7 vehicles have been found. Now, Lordship, regarding the organized fraud is concerned, Lordship, all these cases, numerous cases of fraud have been found, Lordship, and breach of trust, Lordship, across the police jurisdiction.
No, read the definition of organized crime.
Lordship.
Whether
I don't have that. Lordship. If organized crime, there has to be more than one person and it has to be over a period of time. And Lordship, the criminal,
charge sheet has to be,
yes. Now, Lordship, prima facie, Lordship, here 12 cases are registered against him. Under the same sections, Lordship, 406, 420.
no, mere registration would not make it unless there is.
And Lordship, based on that consideration also.
More than one charge sheet is there.
Yes. In the coordinate bench order I have given, Lordship, there also the same plea was taken, Lordship, because Lordship, he was directed to surrender. That was the terms of the interim, Lordship. He was directed to surrender before the concerned court, Lordship, after his treatment. He did not do that yet. Now, Lordship, they have submitted one additional affidavit. It was not filed at that time, Lordship. On probably, Lordship, he was directed to surrender on 7/10/25, if I am not wrong, Lordship. In this case, in the other cases also, Lordship, he was granted interim for a limited time, Lordship. He did not comply with that order, Lordship. Now they are coming with this plea, Lordship, of further treatment. And Lordship, the sections attributed, Lordship, see, it will be 90 days. Now, Lordship, based on the materials available in the case diary, Lordship will take a call. Because, Lordship, the further inquiry is necessary in this case, Lordship. He is a habitual offender. And one more thing, Lordship, he is a flight risk also, Lordship. Because in one of the
He is a
flight risk, Lordship. In one of the cases, Lordship, he fled away to Calcutta. He was arrested from there, brought here, then he was shown arrested in all those cases. In that case also, Lordship, arms act is also there. He fired upon police personnel, Lordship. So he's a flight risk, Lordship. And all these factors, Lordship, led to the rejection of his other bail application by the coordinate bench. At the end of the day, Lordship will have to go by the materials.
in a connected case, bail was rejected.
Yes, I have given the copy, Lordship.
No, my lord. In the other cases, only one bill was rejected, which and other two cases,
That's what I'm
that
saying.
is listed today. because the custodial period is already over, so Lordship wants to see whether really the custodial period is over or not. If it is over, then he is ready to grant bail. That time also, day before yesterday, he was ready to
It
grant
will
bail.
not be over, Lordship, because the offense here is 90 days, Lordship. As he has submitted, he has been under around 50 days. Lordship.
This case is particular, this case I am talking, my lord, not about other cases. In so far this case is concerned, even in the other cases, bail was granted, rejected. So there is no question, I definitely I will arrested. So let this, so far this particular case is concerned, since the merit of the case is there, you will have to go through the FIR. So I am in the custody for 50 days. This,
Even assuming, Lordship, if he has finished, Lordship, even assuming, Lordship, I am not admitting, Lordship, even assuming that it is a 60 days offense, he has completed only 50 days. Lordship will kindly.
No,
go-
otherwise, the allegation against him is that he took 1,30,000 and did not provide the vehicle. That is the main accusation.
Yes.
And he did similar thing with some other persons,
12 other cases.
12 other cases. And whether they have filed independent cases,
12 other cases are different informants in all the cases.
no, whether this Hiranyu Burman,
they are not, yes,
they have not filed.
So that cannot be the consideration only, Lordship. The informant, Lordship, now his locus is put into question, Lordship. He has made one allegation, Lordship, in the FIR. Whether his locus can be challenged just because the other persons have not been, have not filed any FIR, Lordship.
No.
No, we are not on that.
Now, why is that a consideration, Lordship? There were others have filed.
We are on the
one,
merit of the
Lordship.
case, my lord.
Informant has filed an FIR. Whether that merits an investigation or not, Lordship, that is the whole
Yes,
issue.
sir.
What is the progress
Yes,
regarding
that is what
those?
I'm submitting, Lordship. Here, Lordship, will have to see, first of all, his antecedents. 12 cases are registered against him. All the allegations are relating to the same purpose, misappropriation of money. Vehicles have been taken, not given, money has been taken. The co-accused, Lordship, his wife, who was also granted interim protection, Lordship.
What was the date of your arrest?
I was arrested 5/8/25,
5?
8/25.
How many days have elapsed since then?
On 23/10/20, 23/10/25, I was released.
Lordship shown arrested on 1/9/25. In this case, 1/9. In this case, 1/9/25.
1/9/25. He was shown arrest in this case 1/9/25. And released on 23/10/25.
Now, Lordship, coming to the materials of the case, Lordship will have to see the materials against him in the instant case.
Yes.
Here, Lordship will see the co-accused who was granted interim, his wife. She is also involved in the matter. Her bank account was checked, Lordship. There is a,
Therefore,
let me submit.
Yeah,
There are
let-
proceeds of more than 1 crore rupees unaccounted for because she does not have a source of income. That is apparent. And Lordship, all those monies were deposited in her account by way of cash deposit. So it is assumed, Lordship, that all the monies that has been collected in the instant case of the FIR and the other case that have been deposited in her wife's account. From their position, Lordship, around 7 vehicles were found. Now the money trail is being checked, Lordship. So investigation is going on. And moreover, Lordship, the vehicle in question, it has not been recovered. So where have they sold it, Lordship? In all these cases, Lordship, vehicles are taken and they are sold off. And then the money is deposited in her wife's account. So Lordship, this is an organized crime. And Lordship, if admitted.
No, organized crime
Lordship,
under 111. Whether existence of a charge sheet
Lordship.
against the accused, one or more, or
Even assuming, Lordship, even assuming that it's not a 90 days offense, Lordship, it's a
Yes.
60 days offense. Going by his conduct, Lordship, his criminal antecedents and the need for investigation, Lordship, he is around 50 days as per their submission, Lordship. If we assume, Lordship, there is a 60 days offense, it is a fit case to reject the bail application, Lordship. Because also 1 or 2 cases we can understand, Lordship. 12 cases.
You need his custodial interrogation.
Absolutely, Lordship. He has not
You-
been in custody itself, Lordship. He is coming up to one grounds after another, Lordship. And why the interim order was issued under a direction, why it was not complied with, Lordship.
No, for that, they have filed an additional affidavit.
Now, Lordship, what about that date when he was made, asked to surrender, Lordship? He was.
Now, what is your condition?
My condition. Just for complicated surgery, and when I get, I was stated in my affidavit also.
Now,
that I-
can you appear before the investigating officer?
But the protection matter, if we,
No, you are under protection now.
because already they have 50 days custody, what interrogation they have, they have by the, by the time the individual should have been completed, they have not done anything. Police have not done anything, 50 days he was in jail, 2 months in jail. So already 2 months in jail, what they are doing, till now they have not filed charge, why, further investigation is there, I don't know. And why was not an accused here in this case?
Heard Mr. S. Mitra. We are extending the interim bail. Not disposing of. Heard Mr. S. Mitra, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Dharmeshwar Roy, who has been detained who was arrested on 3/10/2025 in connection with Nunmati PS case number 22/,
1951.
was arrested on 1/9/2025 in connection with Nunmati PS case number 22/2025 under section 316 within bracket 2/318 within bracket 4/111 within bracket 2 of BNS. Stop. The learned counsel for the petitioner has submitted that the petitioner was, after his arrest, was under detention for 52 days in connection with this case. Stop. Thereafter, by order dated 15/10/2025, he was granted interim bail on medical grounds. That is, he was on medical ground within bracket likhibo. He was suffering from inguinal hernia and was advised surgery by the doctors, bracket close. Stop. This court, while granting interim bail to the petitioner on 15/10/2025, had imposed a condition that after conduct of the surgery, the petitioner shall surrender before the court of learned Chief Judicial Magistrate, Kamrup Metro, on 7/11/2025 positively, and also file an affidavit in showing compliance of the said condition. However, learned counsel for the petitioner has submitted that the petitioner was the petitioner underwent surgery for left inguinal hernia on 11/11/25 and was discharged from hospital on 15/11/2025. And therefore, it was not possible on his part to comply with the directions of surrendering before the Chief Judicial Magistrate on 7/11/2025. To that effect, the petitioner has filed an additional affidavit showing cause due to which he could not comply with the condition imposed on him while granting interim bail. Learned counsel for this petitioner has submitted that after the surgery, the petitioner was infected with chickenpox and developed post-operative complications. Due to which he had to visit Guwahati Medical College and Hospital and was advised further hospitalization due to excessive infection which arose out of earlier surgical procedure. Under such circumstances, the petitioner stop. Learned counsel for the petitioner has further submitted that the petitioner has already been in custody for 52 days in connection with this case. And considering the nature of accusation made against him in this case, the investigating authorities got sufficient time to investigate the matter, and therefore his interim bail may be made absolute. In alternative, learned counsel for the petitioner has also made a prayer for extending the interim bail on the ground that he suffered from post-operative infection, due to which he was unable to comply with the directions of this court. Of surrendering before the Court of Learned Chief Judicial Magistrate. On the other hand, Learned Additional Public Prosecutor Mr. B. Sharma has vehemently opposed the prayer of the petitioner on the ground that even if it is assumed that the petitioner suffered from post-operative infections, it was incumbent upon him to inform this court before 7/11/2025, as as on the said date, he was directed to surrender before the Court of Learned Chief Judicial Magistrate, Kamrup Metro. He further submits that there has been a willful violation of the condition imposed by the court on the petitioner while granting interim bail, and therefore his prayer for bail may be rejected. He further submits that petitioner has been involved in similar case about how many cases? Another 12 another similar cases wherein the modus operandi taken by the petitioner to deceive the victims are same. He also submits that the wife of the petitioner is also co-accused in some of the cases, not in this case, some of the cases. And during investigation, a huge amount of unaccounted money has been found in the bank account of the wife of the petitioner. So, he further submits that the investigation has not progressed well and the custodial interrogation of the petitioner would be necessary. Stop. I have considered the submissions made by learned counsel for both sides. I have also considered the additional affidavit filed by the petitioner as well as the medical documents submitted by the petitioner in support of the contentions raised by him. Considering the progress in the investigation, this court is of considered opinion that the interrogation of the petitioner may be required in this case. Further interrogation of the petitioner may be required in this case for the investigation to reach its logical conclusions. So, however, considering the medical conditions of the petitioner as it appears from the documents annexed along with the additional affidavit, this court is inclined to extend the interim bail granted to the petitioner by order dated 15/10/2025 till 8th of January, with a condition that the petitioner shall appear before the investigating officer of Nunmati. Where are you now? In one case, you are still.
I will custody by next week because in that case, I was directly Sunday before the land chief makes the number.
Last of Nunmati PS case number 22/2025. As and when so required by the investigating officer before the said date. Stop. If the petitioner is not released in other cases in which he is also accused, then the investigating officer, if required, may interrogate him. In jail, where where he's in jail, stop. Let the case diary be returned back to be called again after updation on 6th of January. List this matter on 6th of January.
After 8th of January, after Sunday, no? Now till date, huh? Let it be done after view matter.
No, 8th of January, there is no direction for surrender.
Acha.
Till 8th of January, you will be on interim bail. On 8th of January, we will decide
Okay.
whether to
Whether to continue or not.
continue, cancel, or allow. January 6th को बात कोई 6th नहीं 8th.
See, matter may be possible for time being. My senior is on legs of court number 15.
Okay.
Please.
Yes, what is
In order, whereby my suit has been stayed on the ground that the subject matter of the two suits. And I will refer to the subject matter of two suits are same. On that ground, my suit, subsequent suit has been
stayed?
stayed by the in order. So in the meantime, there is some further development. After filing of this application, if they have filed an application before the district judge for transfer of both the cases to one single court, single court. So my lord, now they want that both the suits should be tried together.
But your suit has been stayed.
Stayed by the in order, but in the meantime, they file an application for transfer of all the cases. There are 3 cases. They have paid for transfer of all the cases to a single court.
Now they are not, they are opposed.
So that section 10 petition that has become in process.
Yes, Mr. Jain.
My lord,
You are-
If they want that all the suits are tied together, we do not have any objection.
my lord, I'm appearing, my lord, on behalf of the respondent number 3. There are some other respondents also 1 and 2. My lord, it is the fact that we have filed a petition under section 10 to stay the proceedings of the title suit number 713 of 2022. In view of the fact that prior to this, earlier suit was also pending in respect of the same suit property. In respect to the same suit property, so we have prayed before the Honorable Trial Court to stay the suit which was filed subsequently, that is 713 of 22. And accordingly, the proceedings was stayed. But they have preferred this revision petition, my lord. And to my knowledge, only the impugned order was stayed, not the further proceedings of the suit.
That is why they have continued, being the plaintiff, they have continued the proceedings of the suit 713 of 22, and they have examined their witnesses also, and we have also
No,
cross-examined that.
where is the impugned order? In this case,
Directed that this suit should continue. There,
Yes, there is a
Fast
direction
order.
around.
Lordship will see at order dated 8/5/2024.
of this case,
Yes, sir.
yes.
So my lord, in the,
Paragraph, further, it is made clear that the suit will continue to proceed in accordance with the procedure as laid down. So suit is continuing.
What was the impugned order?
In order was that the proceeding of suit number 713.
713 of 22.
330, Lordship,
Page,
330, in order. Book 2. There is a paper book, book 1, page 330. Proceeding of suit number 713 has been stated. 713/22. Lordship will find that cooperative person your petition for stay of the suit is allowed. Last, at page 338. Last paragraph. The proceeding of the suit are stayed till disposal of PS number 258/22. Page 338 and 339. Now, by the interim order, this honorable court has directed that the suit should continue. It is continuing.
no, by the impugned order. 213. Title suit number
258.
713
713
was stayed by the impugned order. By the order dated 8/5/2024, the court stayed the impugned order and therefore suit is continuing. Now they have filed an application for transferring both the suits to a court.
After filing of this application, Lordship.
Yes, my lord, because the proceedings is continuing. And in the meantime, they have also examined their witnesses, and we have given the opportunity to cross-examine their witnesses, and we have done it. So when parallel suits are pending in different courts, we have filed a petition before the honorable district judge that all the cases may be transferred to one single competent court, so that whatever outcome is there,
I am also agree.
that may be decided by the single
no.
competent court, to which my lord.
That is not so easy.
Objection also.
Even if it is transferred to same court, both the two, how many cases are there? 2 cases.
No, actually,
Hello.
these 2 cases, one more.
One
Three
more.
So 3 cases are transferred to the same case,
Because for the same subject matter, for the same property,
same parties.
no, different. I'll come to that. Several agreements were executed by him with different persons. So several suits came to be filed, instituted because of that. Several cases, several transactions. And prayers are different, parties are different, Lordship, cause of action is different, grounds are different. I'll show.
So whether section 10 would be applicable or not.
At the by the appeal, Lordship will see only on the ground that subject matter is same, so the other should stay. How can it be? Lordship, can you see section 10? Section 10. No court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties. So these conditions are not fulfilled here. The issues are different, parties are different.
or between the parties under whom they or any of them claim litigating under the same title, where such suit is pending in the same or any other court in India having jurisdiction to grant a relief claim, or in any other court beyond the limits of established or continued by the central government, or having like jurisdiction or before the Supreme Court. So issues must be same, parties must be same. Now, Lordship, kindly come to the Lordship, I have prepared one chart. What is the prayer? Who are the parties? I prepared one chart. So you can see that. In respect of this subject matter, Lordship will see, first, one case was filed, title suit was issued by the parties were plaintiff, Sanjeev, column number 2, Sanjeev Bhattacharya and Manoj Kumar Sharma. That is another case, 404-19. And parties therein were Padmini, Podumi Bharali, Pawan Kumar Bora, Vikas Raj Kumar. And that suit was.
The execution is that manner, this suit is.
Yes, that suit was disposed of. It was decreed ex parte, and at present it is at the execution stage, and that execution is a state. So I am not concerned with that suit. I was not.
What was the subject matter?
Subject matter, Lordship will see.
The scheduled suit property?
Suit property same. 4 kothas and 4 kothas, 12 vessels land. Tag number same, everything is same. This particular plot of land, Lordship knows. And power of attorney was given to someone, and he executed several agreements with different persons.
So title suit number 404/19 was decreed. Who are you? What is your relationship with the suit land? In whose possession the suit land is?
Now with me also, the respondent number 3, who is power of attorney, he executed one agreement for sale, and he took an advance of rupees 150 crores. Sorry, 1 crore 50 lakhs from me. And in the suit, my prayer is that, apart from other prayers, my prayer is for also refund of the amount. But in the other suit, that prayer is not there. So if this agreement for sale is not going to be materialized, then I want my money back.
Alternative prayer.
And I'm going to file an application before the trial court for refund of that money. So admission decree is admitted by the parties, opposite parties. So I'm going to file an application for to pass an admission decree. So if my suit is stayed, then how I can file that application? And Lordship will see next number 2, title suit 258/22. Their parties are Khairul Hussain, Mohammad Raju Ali. They are the power party holder of.
What is your name?
My name is
Deepak Sharma.
And Deepak Sharma was the pro forma defendant in that suit, 258/22. And Khairul and Mr. Mohammad Raju, they were the power of attorney holder of Ajay Bharali. And they entered into an agreement with me. And therefore, and thereafter, what he did, he cancelled the power of attorney.
In title suit number 258, Khairul and Raju Ali,
The
power of attorney holder. And who is Ajay Bharali? Owner.
I may be. Being the
You
owner
are
of
for
the-
Ajay Bharali.
owner of the suit land.
Subsequently, he cancelled those power. Therefore, Khairul and Mohammad Raju.
Who took money from you? Khairul or power of? Okay.
That's the question.
So 258 is for cancellation of Power of attorney.
Executed in favor of Khairul and Mohammed Raju.
Okay.
So
So
there,
s-
the lordship will see the prayer in that suit. Declaration that the defendant number one is not entitled to get the cancellation of POA number so and so, and for declaration.
So according to you, in 258, issue is different. Issue is relating to cancellation of power of attorney.
No, here also, subsequent case also, cancellation of power of attorney is there. One prayer is maybe similar, but other prayers are also there. That the learned court below.
Who is Padumi Bharali?
Bharali is the sister of Ojal Chandra Bharali.
Paban,
So-
Paban,
Pawan
Paban Bora and Vikas Rajkumar.
Bora
They are the purchasers of the suit line, my lord,
in the earlier suit.
earlier. suit.
And Sanjeev Bhattacharya and Manoj Kumar Sharma.
They were.
They are the power of attorney holders appointed by Podumi Bharani. My lord,
No, how the power of attorney holder will file a suit? It is the purchaser.
They were the purchasers.
Sanjeev and Manoj must be the purchaser.
They are the purchaser.
They are the
And one decree was passed. So according to me, because of that decree, let's say, I may not get the decree for safe performance of contract. So I have alternative prayer.
In your plaint. Okay.
I mentioned my column number 3.
Now what the trial court held in the
Yes,
impugn order?
Page 330. How the matter was dealt with.
This was not within your notice. Title suit 404/9. Okay. Yes. How trial court held that section 10 would be applicable?
Yes. To the operative portion. I'll not go to the facts. Now, let's will come to page 335.
Yes.
Lordship will kindly come to page 334. Third learned counsel for both sides, 334. Various case record and documents submitted along with the petition and objection. The parties relied upon the judgment of the Supreme Court in the case of so and so, in civil appeal number so and so, reported in so and so, and the judgment of the Guwahati High Court in Rana Purokashta versus Himadi Purokashta and others, reported in so and so, so and so. Admittedly, the parties in the title suit 258 of the 2022 and the extent suit are one, and same and suit property in both the cases, issues is also same. But the suit property of the title suit number 404/22 is different. Upon the above mentioned two suits, area wise it may be different, and also in respect of boundaries of the suit property. So, Madam, this finding that admittedly the parties in title suit number so and so and the instance are one and the same. This is perverse.
Why it is same?
One and the instant suit are parties in the title suit number so and so and the instant suit. This is my suit.
Yes, it is same.
Are one.
R1 and the same. Same parties are in both the cases.
But that
No, my lord.
In
Parties
258
are same,
and
suit property is same, my lord, in case number
in 258 and
713.
713, parties are also same.
issues are different.
Issues may be different. Parties are same.
Now, section 10, yes, quoted, Lordship. Then, Lordship will come to the last paragraph. On perusal of the judgment of the Supreme Court relied upon by
plaintiff under defendant number 3, it is seen that in order to attract section 10 of CPC, firstly, the entire subject matter of the two suits must be the same, and secondly, entire. And secondly, the court in which the previous suit is pending is competent to grant the relief claim. The court held that the fundamental test to attract section 10 is whether on final decision being reached in the previous suit, such decision would operate as later in the subsequent suit. Question of execution does not come because the suits are not decided as yet. In the extent suit filed by the plaintiff, that is performer defendant number 2 of petition number 258/22, prayer has been made for a specific performance of agreement dated so along with declaration that the deed of cancellation revocation being deed number so dated so, cancelling the power of attorney dated so is null and void. So it is seen that in petition number 258/22, the plaintiff.
We will continue it after lunch at 2. At 2 we'll continue.
This petitioner have been served a eviction notice on 25th of December, and 15 days time has been given, and that period is expiring today. So at 4 or at 3 p.m. 30. Item 14.
Item
14.
at 4 p.m.
Publish.
60.
Page 336.
Yeah. I think it's okay. Then I have read, that's it, page 335. Then next page 336. Second para. In the extent suit filed by the plaintiff, that is performer defendant number 2 of DS number 258/22. Prayer has been made for a specific performance of agreement dated so and so, along with declaration that the deed of cancellation, revocation being deed number so and so, cancelling the power of attorney dated so and so is null and void. That is one of the prayers. It is seen that in TS number 258/22, the plaintiff, that is the defendant number 1 and 2 of the instant suit, have also entirely paid for declaration that the cancellation revocation deed number so and so dated so and so is null and void, and for cancellation revocation of the cancellation deed of attorney number so and so executed by defendant number 3 of the instant suit on perusal of pleading. That's you got it, page 337.
Who sold you land? The power of attorney holder.
Agreement for sale was executed by the power of attorney.
Power of attorney holder. Suppose the power of attorney is cancelled in 258. Then there may be a conflict of decision.
Even if power of attorney is executed, my lord, part of that deed was already executed. So he is bound by that. He or the power of attorney holder is bound by that. Whatever is already executed, because he took money. So he cannot accept liability. So that part is already done. Thus you can see section 202 of the contract. $204.
Okay.
$204.
Yes.
The principal cannot revoke the authority given to his agents after the authority has been partly exercised. So far as regards such acts and obligations as arise from acts already done in the agency. So part of that agreement is already exercised. He entered into an agreement and he took some money, advance money.
So thereafter, he cannot avoid liability of exercising the other part of the contract.
Okay. In
Those are
two-
required to be
in-
done into,
In title suit 258, on what ground the power of attorney is sought to be cancelled? On what ground?
because it was not legally done, because in order to cancel power of attorney lordship, notice has to be given. So as to that, it should be made known to the parties who are involved in the suit. Without notice, you cannot revoke power of attorney. Now, lordship, yes. The provisions are there in the contract act itself, lordship, how it is to be revoked. So those matters, lordship, it will be decided in the suit. There are several grounds whether the power of attorney can be.
No,
revoked.
no. I am on the question
Yes,
as because same prayer is in both the suits.
not same prayer. Lordship, I have prepared this up. Lordship, it is very, very clear. Prayers are different. Yes,
Cancellation of that power. Cancellation of revocation of cancellation deed is
Yes.
prayed for in earlier suit also.
one prayer is same.
One prayer is same. In
Not more.
respect of that,
That is same.
there may be conflicting decisions.
Therefore, my lord, all the suits should be decided together simultaneously. It cannot be said that my suit will be stayed because I have different prayer. I may not go for the other relief claim. I may seek other relief, alternative relief. Because by now, it is clear that that agreement is not going to be materialized because already there is a decree as regards the earlier agreement for sale. And court directed that to execute the sale deed. So now only I have come to know. So now I will seek for refund of the amount. And if my suit is stayed, then what will
No,
happen?
it is only stayed. Your suit is stayed subject to till the earlier suit is decided.
Oh, that is there.
Because the outcome of the earlier,
How does it will come to section 10? When the suit can be stayed? What is the law?
yes,
Only because of the fact that only part of the subject matter is same, only on that ground whether the subsequent suit can be stayed. Now, lordship, therefore I want to take your lordship to the chart again. Lordship, can you see the prayers, different prayers? The lordship has already seen. I have one additional prayer. And now the lordship will come to the impugn order again. In the learned code below has mentioned that subject matter of the suit, both the suits are same. Only on the ground my suit was stayed. What about the parties involved in the suit? What is the cause of action in both the suits? What is the prayer? All these things were not discussed or considered by the trial court. And rather, I'll submit that this judgment is totally perverse, beyond the record, contrary to record, lordship. Lordship, first, let me read the judgment first. Then I'll come to section 10 at page 337.
yes.
337, on perusal of pleadings of title number 258/22 and the instant suit, it is seen that matters in issue in both the suits are substantially same with a common prayer for cancellation of revocation deed that number so and so dated 6/11/20. That is correct, lordship. But whether all the issues involved in the suit are same or not, that is not considered. The learned court has held that all the matters in issue in both the issues are substantially the same.
Not all, only one prayer. The same. That admittedly, yes, the same. But what about the other prayer? The object of section 10 CPC is to prevent force of concurrent jurisdiction from substantially trying two parallel suits in respect of the same matter in issue. The object is to avoid recording of conflicting findings on issues which are directly and substantially in issue in the previously instituted suit. The expression, the matter in issue was interpreted in so and so, in the following words: unless the decision of the suit operates as adjudicator in the other suit, it cannot be said that the matter in issue is directly and substantially the same in both the suits. In other, that the matter in issue is directly and substantially the same in both the suits. That is to say, the decision in one suit must non-suit the other suit before it can be said that the matter in issue in both the suits is directly and substantially the same. As discussed above, the matter in issue in both the suits are relating to cancellation of deed of revocation, being deed number so and so, so and so, so and so. So this is not correct, the lawsuit. This is perverse. The entire subject matter, lawsuit will see, this is very, very important. The entire subject matter, that is the suit property as well as the matter in issue, are the same in both these suits. The Court of Civil Judge number 3 is competent court to grant relief claim. Any decision in the previously instituted suit in respect of the matter in issue would operate as adjudicator in the instant suit. That apart, conflicting decisions may come up by two separate courts of competent jurisdiction. If the same matter is in issue is tried by two separate courts simultaneously and parallelly, it is therefore found that so and so is attracted and instant suit and hence petition number so and so is allowed. Now, as you have seen, the chart pairs are different, causes of action are different, parties are also different. Let's see in the let us forget about serial number 1. That is already decided. I am not involved in the suit. Let's will come to serial number 2 and 3. So serial number 2, that is petition number 258/22. That's it. Parties are different. The power of the holder, they challenge the revocation. That is Khairul Hussain, Mohammad Raju Ali.
Parties are same, but in different capacities.
No, parties, plaintiff different. Plaintiff different.
No, plaintiffs are the respondent, defendant in the 713.
Yes. Yes, they are different in there.
Parties are same, but not in the same capacity.
Not in the same capacity. Their grounds are different. My grounds are different. Therefore, causes of action also different. Then see defendant Ajay Chandra Bharali, Deepak Sharma. I was the co-founder defendant. So there was no relief claim against me. Basically, see. And I was the co-founder defendant there. Therefore, I cannot file a counterclaim also. Therefore, I had to file another suit for realization of the money, for refund of the money. Basically, that is my prayer now. So what will happen to my prayer? If I am to wait till disposal of that suit, I may forego the other part, other prayer. And then I may ask for refund of the money already paid. So what will happen to my prayer? And I can file my application for admission decree as regards that part of the suit. So I only want that. My prayer is very, very limited. Let it be tried together. Instead of waiting for the disposal of that suit, I may not go for the for other relief. So I am handicapped, and he will not be prejudiced for that. How he will be prejudiced? And lawsuit now, I would like to refer to some judgment. Supreme Court. Two 13/4 SCC, page 333, triple 3. So I'll come directly to, I will not read the other part. Paragraph 9. 9, page 337.
Yes.
From a plain reading in the opposite provision, it is evident that where a suit is seated in a court to which provisions of the code apply, it shall not proceed with the trial of another suit in which the matter in issue is also directly and substantially in issue in a previously seated suit between the same parties for application of the provisions of section 10 of the code. It is further required that the court in which the previous suit is pending is competent to grant the relief claim. The use of negative expression in section 10, that is, no court shall proceed with the trial of any suit, makes the provision mandatory, and the court in which the subsequent suit has been filed is prohibited from proceeding with the trial of that suit if the conditions laid down in section 10 of the code are satisfied. The basic purpose and the underlying object of section 10 of the code is to prevent the course of concurrent jurisdiction from simultaneously entertaining and adjudicating upon the two parallel litigations in respect of the same cause of action. This is important also. Same subject matter and the same relief. Your relief claim are different. This is to pin down the plaintiff to one litigation so as to avoid the possibility of contradictory verdicts by the two courts in respect of the same relief, and is aimed to protect the defendant from the multiplicity of proceeding. Then Lordship will go to paragraph 11. Next page. In present case, the parties in all the three suits are one and the same, and the court in which the first two suits have been instituted is competent to grant the relief claim in the third suit. The only question which invites our jurisdiction is to whether the matter in issue is also directly and substantially in issue in previously instituted suit. The key words section 10 are the matter in issue is directly and substantially in issue in a previously instituted suit. The test of applicability of section 10 of the code is whether on a final decision being reached in the previously instituted suit, such decision would operate as in the subsequent suit. To put it differently, one may ask, can the plaintiff get the same relief in the subsequent suit? If the earlier suit has been dismissed, in our opinion, if the answer is in the affirmative, the subsequent suit is not fit to be stayed. However, we hasten to add, then what the matter in controversy is the same. When the matter in controversy is the same, it is immaterial what further relief is claimed in the subsequent suit. That will be applicable in my case. As observed earlier, the application of section 10 of the code, the matter in issue in both the suits have to be directly and substantially in issue in the previous suit, but the question is what the matter in issue exactly means. As in the present case, many of the matters in issue are common, including the issue as to whether the plaintiffs are entitled to recovery of possession of the suit premises. But for application under section 10 of the code, the entire subject matter of the two suits must be the same. That part, Lordship, the impugn order, in the interim order, impugn order, there is no mention about that. But the entire subject matter is the same. In other words, the matter in issue is not equivalent to any of the questions in issue. As stated earlier, the eviction that is on the facts of the case. Lordship again now come to. So that is
Now presently, both the suits are pending before which court? Different courts.
Two different courts. One
Whether that transfer.
Kamrup Metro at Guwahati.
No, you have filed an application for transfer of the.
For transfer of the cases so that all the cases.
No,
may be
whether what
tried up
happened to
together.
that application?
Hello.
What happened to that application?
That notice has been issued to them also. And there are three opposite parties, two of them appeared. And case record has also been called for. And matter is still pending for final hearing.
Lordship will consider one thing.
3 days ago, the matter was fixed for calling for the record. The record has come, out of the 3 cases, 1 record has already come to the court of the district judge. 2 records are yet to be received. So the
Lordship will
matter is
consider
to be
one thing.
fixed for hearing.
My prayer in the first suit, that is my suit, is also alternative prayer is there. That prayer is not there in the earlier suit, that is 258, Lordship. And even if that suit is disposed of, Lordship, I am not getting that other relief. Alternatively, I am not getting. I have to file the suit. That suit must proceed.
No, suppose in the earlier suit, suppose the earlier suit is dismissed and the prayer for revocation of cancellation deed is rejected. Would it not impact your case?
No, because alternative means that relief is there. I am entitled to get back the refund
From whom?
from the owner as well as the
No.
power of attorney holder.
How it will be from
I'm not
owner?
at all involved in the execution of the
No,
power
no,
of attorney
no,
or
no.
the acceptance of the money
Let
matter.
me complete my
No,
submission.
I am putting hypothetical questions. Suppose 258 is allowed, 258 is dismissed, where the power of attorney holder has prayed for revocation of the cancellation of the power of
This
attorney.
is why my last section 202 is there. Earlier part, you cannot avoid his responsibility. He has accepted the money. That part will operate. And I.
No, you have paid money to the power of attorney holder, not to the,
On his behalf.
No.
Those will say,
when have you paid money? No, whether before the execution of cancellation deed, before 6/11/2020.
before cancellation. And also will say the power of attorney holder, that is the plaintiff in petition number 258/22, Lordship, they have admitted to have received the amount. They admitted case. Therefore, my lord.
No, when have you paid the money? You are claiming to have paid money to the tune of 1,50,00,000 lakhs.
This is an admitted question.
What is your case? When have you
Respect
paid?
to the Evidence will be there.
No.
The evidence.
I just want to, this is important. Because your
She will find.
agreement was of 5/3/2020.
Yes. Son, part of the, now we have.
No, you need not to read. You just tell me, when
Yes,
have you
several
paid?
dates.
In installments you have paid.
I can supply a copy, furnish a copy to your lordship. As on 13/3/2020.
13/3/2020.
My lord, agreement date 05/03/2020. And
That was the agreement. When is the last installment paid?
Last summer. About earlier part, he has to comply.
When is the last installment paid?
Probably, my lord, it is on 13/3. 13/3/2020.
Okay.
And I started paying from 6/2/2020. The starting date is 6/2.
13/3, that is before the date of execution of the cancellation deed. No. Cancellation deed was 6/11/2020.
6/11.
Okay. So even if the suit fails, the owner or the power of attorney holder would be liable to.
Cannot escape. They have to, because this is a case of fraud. Every time same suit line has been,
Okay, what else is your submission?
this one, but then another one is also there. Entire issue involved in the suit are not same. That prayer is not there in the earlier suit for refund.
Where is the prayer portion, page number? Plaint of the 713,
Page 58, may kindly be seen.
huh?
Page 58.
Page 58.
No, plain is in page 34.
No, no, prayer.
Prayer is 58. You got it? For declaration to the effect that the deed of revocation bearing number so and so, cancelling the power of attorney so and so, executed by the defendant tree is bad in the eye of law and liable to be declared as null and void and not binding upon the entity. A declaration to the effect that deed of revocation bearing number so and so, cancelling the power of attorney number so and so, executed by the defendant tree.
Okay, okay, alternative prayer is there.
What is liable to be cancelled by issuing precept to that effect. A decree directing specific performance of the notarized agreement that is so and so, or executing the registered deed of sale by obtaining necessary permission from the appropriate authorities in respect of the schedule of property, and or in the alternative, a decree of refund of the entire amount of rupees 1,450 lakhs only together with interest at the rate of 12% and an amount of 5 lakhs. The prayer for compensation is also there towards damages and or compensation for breach committed by defendants payable jointly and severally by defendant 1, 2, and 3. The earlier suit, this prayer cannot be granted. So my prayer is different. Issue, that is one of the issues. That issue is also, and different issues have been framed in both the suits.
Okay. What else is your submission? Anything else?
Or another judgment.
On what point?
Same point, but that is also relevant.
On same point, why you need more than one judgment?
No, not just to, because no, yes, I will refer to, I'll not read that, only paragraph one. And
Yes.
one is a copy. That is reported in 2005 to SCC 256.
Give a copy.
So you can refer to the paragraph. Paragraph citation is 2005 to SCC 256.
You are giving, furnishing a copy?
Yes. And
Yes.
paragraph numbers, Lordship. 8, 10, and 11. Entire issue must be same, not only one or two. And here prayers are different completely. That prayer, my prayer is not there in the earlier suit. So how can I get the relief? That relief, I'm entitled to. And I can go for admission degree as regards that part. I may forego the other part. Definitely I have to forego now. No other option left because already yes.
Suit has been decreed in the first suit.
Only decreed, that is at the execution stage. So I am not, so for that matter, why should I wait for so much time? My client is also ready.
Okay. Yes.
Proceed. May I please? Lord, as far as this table of suit is concerned, number one, title suit 404 of 2019. Here, my sister has executed power of attorney
But the,
concerning the whole plot of land
no, but
without my knowledge.
I have a query.
My lord,
The impugn order has not considered title suit 404.
my lord.
Impugn order has stayed the in 3713 in light of the existence of title suit 258.
Yes,
It has not considered 404.
not considered because only of the fact that parties are different. But my submission before your lordship is this suit property is the same as that of the earlier two cases, 258 and 713. So that case has gone to the stage of execution. When I have come to know, I have filed an appeal. Appeal is pending before this honorable court. Notice has been issued because it is my land. My sister somehow very wrongly, very fraudulently executed power of attorney and executed a deed of agreement in support of the plaintiff. And the execution has also been, decree has also been passed. So when I have come to know, I have filed the appeal, that appeal is pending in connection with the same suit land, though the parties are different. That is so far as title suit 404 is concerned. But now I am coming back, my lord, title suit 258 and 713. Suit property is same. Admittedly, suit property is same. First, the suit has been filed 258. That description of the suit at page 226 of their petition. 226, page number 226. Description of the suit line. Plot of land measuring so and so, kata, bigha, or covered by dag number so and so. And here the description of the suit land of 713 case is page 61. So page 61 and page 226, it bears the same suit land in connection with two different cases. So suit land is same, entire suit land is same. And here I'm coming that here the plaintiff has become the defendant and defendant has become the plaintiff. My learned senior brother has stated that in the title suit 258 of 22, defendant number 2 was only the pro forma defendant, but he has already filed his written statement contesting the suit. So he has been also contesting the suit in the title suit 258-22. Thereafter, he has filed his own case being plaintiff, that is TS 713-22 in connection with the same suit line. So decision of the earlier case may affect, outcome may affect to the other cases. They cannot deny because the suit property is the same. Transactions, that is sale and purchase of the suit land is the same. So entire suit land is same and parties are almost different. Capacity is different. As your lordship has also observed, here the plaintiff has become the defendant, defendant has become the plaintiff. But if one decision may affect the other cases.
How it
that
will
is-
affect?
My lord,
The power of attorney was revoked
my lord, because I am,
on
yes, my lord,
6/11/2020.
my lord, I am.
Whereas the contract which the petitioner is seeking specific performance of was executed much before 6/11/2020.
My
So
lord,
it will have no impact on their case, or whether will it have any impact? How?
because my lord, I am the owner of the land. They say that power of attorney had been executed by me. But
Yeah.
in my title suit, in my reply, in my written statement, I have denied that no such power of attorney is executed by me. It is a fraud, fraudulent document. So my lord, entire case is based that intention of the power of attorney holder is not good. Somehow they have obtained my signature in the name of the power of attorney. But when I have come to know, I have cancelled my power of attorney. And I have not received any single money from the purchasers, intending purchasers, maybe the plaintiff, maybe the defendant. I'm not at all associated with the receipt of the money or receipt of any money transaction. So the suit has been pending before the honorable court in the same district, two different courts. And my lord, interestingly, one more information is also there that is not, of course, involved in
Where is
this
the
suit.
cancellation deed number 310 dated 6/11/2020?
Yes, my lord. When I have come to know that
Whether that deed is there in record,
in the record, my lord,
where?
they have not
You have
signed
annexed it.
the title suit.
Whether any
Copy is not.
copy is there.
In my reply, I have not submitted copy of the.
Do you have the copy of that
They
cancellation
they
deed?
must have the copy of the cancellation of the deed, because. Yeah, possible. Reclaimed order, permission order. No, cancellation is not available. Cancellation. Cancellation revocation different. Cancellation revocation, page 124, from 124 to 129. 124 of the petition. Is the cancellation of the deed of general power of attorney, registered cancellation deed that was executed on 06 November 2020, 6 November 2020, 2020. And prior to this, my lord, I have issued notice to them. Because when they have exceeded their authority, when they have already started taking money from some various purchasers, intending purchasers, and when I have come to know that some forgery has been committed by them, I have issued notice to them, but instead of they have not come forward. And that is why I have cancelled their authority. Because it was not executed by me at all. It was a fraudulent document. And all these things are subject to the trial suit now. So, Your Honor, well, the first title suit, that is 258 of 22, has some important role to play here to decide the matter of the instant suit of 7132.
No, you read.
Hello.
Come to page 125.
The cancellation deed, general
Read.
power.
Read second paragraph.
Second, but that on 26/02/2020, the executant by registered deed number so and so, Ajay Chand Baral, son of that so and so, aged about so and so, by religion so and so, district Guwahati in the district Amsam, have executed a general power of attorney in favor of Khairul Hussain, and number 2, Muhammad Raju Ali, son of so and so, in the district of Nalbari, for transfer of the land mentioned in the schedule below in terms of the manage and supervise of the said property. Thereafter, page 127, that a general power of attorney has been obtained from the aforesaid landlord fraudulently and without their proper knowledge about the execution of the power of attorney. As such, now the executant hereby cancelled the said general power of attorney after giving notice to the attorney holders. Then next, by the said general power of attorney, whatever power has been executed by the executant with regard to the scheduled plot of land to the attorney holders has transferred once again in the hand of original owner, possessor of the said plot of land by the constituted attorney holder from the day signing of this deed of cancellation. After signing of this deed of cancellation, neither the constituted attorney holder nor their legal heirs representatives can ever claim any sort of right over the scheduled plot of land. My lord, it was a fraudulent document. When I have come to know, I have taken steps. I have issued notice to both the attorney holders. And thereafter, with due process of law, I have cancelled authority, which they have challenged by way of filing the title suit and which is still pending. So let it be decided first whether this document is to be revocable or not. If it is revoked, then the other prayers may come up. So unless the first suit is decided, the outcome of the second suit, it cannot be continued. So here the stay is required very much. That is why section 10 has been invoked. And we have filed rightly as
Who is representing? You are representing Respondent number 3 in this.
Three,
case.
my lord, only three.
Who is
Honor of the land.
representing 1 and 2?
1 and 2 are represented by some other advocates in the trial courts because they are the
Right,
attorneys.
in this
at
case,
this stage. I am the owner of the land. And still the plot of land, the scheduled suit of land is in my possession. Till today, it is in my possession.
no, who is representing 1
1
and
and 2, here also, nobody has come. I see.
whether this case is proceeding ex parte again?
On last occasion, some learned advocate appeared on their behalf, I think.
Yes. Mr. N. Bhuya.
But we'll see that from their plane, other parties, in that power holder, he admits in his own suit that he received an amount of rupees 1 crore 50 lakhs from them. If he is not liable, then he will be liable. He admits. Yes.
They are not my collecting agent on my behalf. I have not appointed them to collect the amount.
Yes, they are.
Yes. No,
Relate-
let
I have not,
let him
authorized
complete.
them, my lord. If
Yeah.
they admit that they have taken the money, it is at their own risk.
No, civil
At their own risk of
on
the
to page
plaintiff paid
140.
the amount.
Page 140, for a moment. Book number 1. On four, book number 1. This is the suit filed by Khairul Hussain, Razu Ali. Assessment number 258, 2022. Page 142, paragraph 7. They are the plaintiffs here. But the plaintiffs state that as per the said negotiation dated so and so, the plaintiffs by receiving an amount of rupees 1 crore 50 lakhs only as advance have entered into a notarized agreement for sale being student number so and so before the notary, public at Guwahati for selling, transferring scheduled land in favor of performance defendant. Performance defendant means the plaintiff in the Deepak Sharma, plaintiff in my suit. With the knowledge and acquisitions of defendant number 1, it may be mentioned here that that out of the said amount of rupees so and so, 1 crore 50 lakhs, and amount of rupees 45 lakhs rupees so and so was paid to the plaintiffs prior to the signing and executing the said notarized agreement for sale, and another amount of rupees 1 crore 5 lakhs was also paid to the plaintiffs at the time of signing the executing the said notarized agreement in favor of the defendant number 2. Thereafter, as per the said negotiation, the plaintiffs have executed the registered agreement being number so and so for selling the scheduled land in favor of the performance defendant with the knowledge and acquisitions of defendant number 1 on the same day of execution of the notarized agreement, that is so and so. So, my lord, the payment is admitted by
Admitted by the power of attorney
Yes.
holders. Yes,
Said by
please
power of
continue.
attorney order, but my lord, in our written statement, we have denied totally. And such statements are completely wrong, false, baseless statements
why
have been
I'm-
given by
Let,
the.
let him complete.
My
please.
lord. My lord, when we have received the summon, we have entered our appearance and we have contested this suit by filing the written statement. And never we have admitted any receipt of the payment from their side, either through the attorney holder or directly by them. Because we have never given the proposal to sell our suit land. Never given the proposal either through the attorney holders or otherwise. Now it is their case, it is subject to the evidence. That is why suit is pending. And we have already cross-examined the witnesses of the plaintiff side.
this stage.
At this stage, suit is pending. That is why my respectful submission before your lordship is that both the suits are pending. First suit is, second suit is. And prior to that, one earlier suit is at the stage of the execution, we have filed a revision before the honorable court here. So, my lord, all the cases were still pending. And my lord, apart from that, if I'm allowed, to submit one more case has been filed, though it is not associated with this present suit. In connection with the same suit line, we have received a summon, that is the title suit of 2023. When received summon, we have also filed our written statement. That is also pending in the court of the civil judge number 1. So civil judge number 1, 2, and 3, in all the 3 courts, 3 title suit has been pending for disposal in the same district. In the suit, we have been implicated as the defendant number 1, and suit line is same. Here the plaintiff is different. And the agreement has been made by both the attorneys, claiming that still they are the attorney, though we have cancelled the attorney, but still they have taken some money from the intending purchaser and executed an agreement on our behalf. Whereas we have already cancelled. Of course, this is not associated with this present suit, but still we are facing the trouble because of the attorney, because of the fraudulent activities of the attorney. So this 4th case is also coming back. That is suit number is 1717 of 2023, still pending in the court of civil judge 1, and next date is 27 January 2026. Another suit is there. Well, this type of activities is being done by some fraudulent persons.
And that is
Because I am a poor person. I may be a poor person, but I am having a plot of land at a very prominent place at City Guwahati. And somehow they have come to know that I am having a vacant plot of land because there is a very small house upon this suit land, and they have taken the money. Though we have cancelled, still they are collecting the money. But how far I am responsible for this? That is, of course, another matter. But it will come also in the picture later on. So if they have paid the money to the attorney holders will repay the amount to them. We have nothing to say, but that will be decided in the suit itself. So before this first suit, which is filed by the attorney holders themselves, had it been a case that the suit has been filed by some other person, matter would have been different. But here the first suit has been filed by the attorney holders. So let it be decided first of all, because the outcome of this first suit is very much dependable upon the second suit also. And otherwise, it will be a matter of the res judicata. Once it is decided, it will affect the subsequent progress of the case. So my humble submission is this, that the learned court below has done nothing wrong while staying the suit. So the rest stay is very much required. That is the subsequent stage of the case of PS 71322.
So I have one suggestion. Now he has admitted that there is another suit pending.
Yes. Thank you.
That is pending before another court.
Another
3
court.
suits now. So let it be tried together. And because of the subsequent development that he has filed an application for transferring all the suits to one court, including that suit, which is not involved in it. So let it be tried together. How they are this. So now he cannot press that application under section 10 after filing the application for transfer to try the suit together. And there another suit will be involved. Now,
No,
suppose
his section 10 petition has already been allowed.
that is why we have
We
approached.
have to only see that whether impugn order is right or wrong.
No, other part also, whether they are PGGs or not. This is an application under 227. Whether this can be done by way of an application under 227. That part also is there. Unless there is miscarriage of justice, that order should go. And their application should be considered for transfer. And there another.
That transfer application is not before this court.
I'm not saying that. We have filed additional affidavit regarding that.
Heard, Mr. Anything else? This is item number. Heard, Mr. P. Khatuniar, learned counsel for the petitioner. Also heard Mr. A. K. Jain, learned counsel for respondent number 3. No one has appeared for respondent number 1 and 2. Though name of two counsels, namely M. Kashyap and S.A. Singh, are shown as engaged counsel for the said respondent in the cause list. It also appears that on last date, that is on that is on 15/10/2025. Mr. N. Bhuya, learned counsel, had appeared on behalf of Mr. N. Kashyap, learned counsel for respondent number 1 and 2. Since no one has appeared for respondent number 1 and 2, this court decides to proceed ex parte against the said respondent in this civil revision petition. Stop. This civil revision petition within bracket IO under Article 227 of the Constitution of India has been filed by the petitioner Deepak Sharma, impugning the order dated 22/2/2024 passed by the Court of Learned Civil Judge Senior Division number 2, Kamrup Metro at Guwahati. In title suit number 713/2023, whereby the application filed by respondent number 3 or filed by respondent number 3 under section 10 of the Code of Civil Procedure, read with section 151 of the said code, was allowed, and the further proceeding of title suit number 713/2020, along with the Ms. J case number 1116/2022, was stayed. The facts relevant for consideration of the instant revision petition are that ... Dibu. I'll dictate later on. Stop. Learned counsel for next para. Learned counsel for the petitioner had Mr. P. Khatwaniar has submitted that the trial court had heard by trial court had heard while passing the impugn order by staying the further proceeding of by staying the title suit number 713/2022 in view of pendency of title suit number 258/2022, inasmuch as it failed to consider that the entire that in both the suits, cause of actions were different and different reliefs were prayed for. he submits that the trial court, while passing the impugned order, failed to take into consideration that the entire subject matter in both the suits were not same. He submits that in title suit number 258/2022, the plaintiffs were the power of attorney holder, namely power of attorney holder of the present respondent number 3. And a power of attorney holder, namely Khairul Hussain and Mohammad Raju. And the main relief which was sought for in the said suit was a declaration that the defendant number 1 of that suit, within bracket owner of the suit land, Ajay Chandra Bharali, is not entitled to get cancellation of the power of attorney number 908. As well as also not entitled to declaration that the cancellation deed number 3109 dated 6/11/2020 is illegal, null and void, and not binding on the plaintiffs of that case. The other relief which was sought for in the title suit number 258/2022 was revocation/cancellation of the cancellation deed number 3109 dated 6/11/2020 and for issuance of precepts to that effect. He submits that though one of the prayer in the title suit filed by the present petitioner, that is title suit number 713/2022, was common to that of the prayer of title suit number 258/2022. However, the main relief sought for by the present petitioner in title suit number 713/2022 was for specific performance of an agreement of the agreement dated 5/3/2020, which was executed between the present petitioner and the power of attorney holders, namely Khairul Hussain and Mohammad Raju Ali. Stop. He submits that an alternative prayer was also made in the plaint of the present petitioner to the effect that where is your prayer? Your plaint?
713.
713 plaint.
One sixty.
160? No,
That's it.
58.
34 to 63. Prayer is in 62.
58.
Yes, 58.
Last line. In the plaint, in the plaint to the effect that no, to the effect like, made in the plaint of the present petitioner for refund of entire amount of rupees 1 crore 50 lakhs along with an interest as well as cost towards along with an amount of rupees 5 lakhs towards damages. He submits that learned counsel for the petitioner further submits that now the petitioner has also come to know about title suit number 404/2019, which was also in respect of the same lot of land, which is the subject matter of title suit number 713/2022. In the said case, the suit has already been decreed in favor of one Sanjeev Bhattacharjee and Manoj Kumar Sharma, and the said suit is pending at the stage of execution. What has happened to execution?
My lord, when we have come to know, we have preferred an appeal under.
Execution has
order
stayed.
41 CPC. And we have also made a prayer to stay the execution proceedings, but that prayer was not admitted because of the fact that we are not the party to the original suit. That is why we have preferred the appeal before the honorable.
And there is no stay.
There is stay, of course, but not on the basis of the my petition, but the petition filed by them.
Under order 21,
Where? In that suit?
the execution procedure.
Learned counsel for the petitioner has also submitted that the petitioner has in the meanwhile filed an application before the
Column number, last column, my chart, I mentioned, and page also I mentioned. The order also
filed an application in title execution case number 26/23. And by order dated 24/7/2023, the further proceeding of the execution case has been stayed, has been kept in abeyance till disposal of Ms. J case number 756/2023, which was registered on the basis of an application filed by the present petitioner under Order 21, Rule 97, 99 and 101 of the Code of Civil Procedure. Stop. He submits that as an alternative prayer for refund of the advance amount has also been made in title suit number 713/2022. The petitioner may not press the other relief sought for by him in the said title suit and may press for refund of the advance amount from the respondents, from the defendants of that case, he submits that said relief would not be affected by the outcome of title suit number 258/2022 as hence 252 of 2022. Hence, he submits that the trial court was not correct in staying the title suit number 713 slash 2022 merely on the ground that the subject matter of both the suits is the same. No, the land involved in both the scheduled land involved in both the cases is same. He submits that it is essential for applicability of section 10 of the Code of Civil Procedure to a subsequent suit that the entire subject matter in controversy must be same in the previous suit as well as in the subsequent suits. Mere existence of common relief in the previous suit as well as in the subsequent suit would not attract the provision of section 10 of the CPC. In support of his submission, learned counsel for the petitioner has cited a ruling of the Apex Court in the case of ASPI Jal, ASPI-JL and another versus Khushbu Rustam Daddy Buzor, DADYBUZR, Burzor, reported in 2013 4 SCC 333. He has also cited another ruling of the Apex Court in the case of National Institute of Mental Health and Neurosciences versus C. Parmeshwara, reported in 2005 2 SCC 256. Stop. Learned counsel for the petitioner has further submitted that in the meanwhile, the respondent number 3 namely the owner of the suit land has moved an application before the District Judge Kamrup Metro for transferring which case?
Both the cases, TS 258/22, TS 713/22,
And also,
along with TS 40,
and another cases that
Uh,
also included.
To which court?
along with 17 of 2020.
To any court. One court, without mentioning any court.
In any competent court of law as decided by the court.
To
We have not preferred any particular court.
last line. For transferring title suit number 404/19.
The 404/19 already disposed of.
Not that one.
258, 713 and
trans-
one more case 17. That is not of.
For transferring title suit number 258/2022, comma, title suit number 713/2022, and title
That's
suit
another
number
case, title suit 17 of 2023.
17
Pending
of
in the court of civil judge
17 of 2023,
2023.
2023, to a single court, to a common court,
That
So-
regard, I have filed an additional affidavit by enclosing that application, Lordship.
in this case,
This way. They are not replied to that. Additional affidavit I have filed
where is that
because
edition?
of that subsequent development.
Where is
It
that
was
edition?
filed on 29/10/2025.
Yes, we
I
have
think,
received it.
I think it is not tagged with the record.
It is not with the record.
Can we call for?
Give a copy.
I have soft copy to them also.
Yes.
There we have enclosed the application also. Their application for transfer.
Last line. So that there may not be any conflicting judgment in the aforesaid suits. He submits that uh, he submits that he submits that the present petitioner does not have any objection to transferring of all the cases involving same subject matter to a common court so that there is no conflict of decisions. However, he submits that if the present suit, that is title suit number 713/2022 is allowed to be remain stayed till the pendency of the title suit number 258/2022. The present petitioner would be highly prejudiced as it will debar him from pursuing the alternative remedy of refund of the advance money, which the power of attorney holder have already admitted, accepting in their written statement.
Yes, good filed by them.
In
That
this,
is in the
in the
title.
plaint of the suit filed by them, that is title suit number 258/2022. Stop. On the other hand, Mr. A.K. Jain, learned counsel for the respondent number 3, has submitted that the impugn order passed by the trial court does not suffer from any infirmity and does not warrant any interference by this court. He submits that the power of attorney number 908/2008, 908 dated 26/2/2020 was obtained by the respondent number 1 and 2 of this case, namely Khairul Hussain and Muhammad Raju Ali, fraudulently by obtaining the signatures of the present petitioner. he submits that the said power of attorney has already been cancelled by the defendant number 3 by executing a cancellation deed number 3109 dated 6/11/2020. He also submits that since the deed of cancellation, the aforesaid deed of cancellation is put to challenge by the power of attorney holder in title suit number 258/2022. And same has also been challenged in the title suit number 713/2022 by the present petitioner. The subject matter of both the suits are same, and the outcome of the title suit number 258/2022 is going to affect the outcome of 713, title suit number 713/2022. Hence, he submits that unless the subsequent suit is stayed, there may be conflict of decisions over the same issue by two different courts. Stop here. Regarding transfer, you don't have an objection.
We have preferred the transfer application, so we have not used it. If the transfer is made to some other competent court. All the cases may be transferred to one competent court.
That you have filed.
We have filed the petition and the notices have been issued to them.
However, learned counsel for respondent number 3 has submitted that since the impugn order, since the operation of impugn order was stayed by this court by its order dated 8/5/2024, and since the proceeding of title suit number since the title suit number 713/2022 was proceeding in its normal course, the respondent number 3 had preferred an application before the district judge Kamrup Metro for transferring both the cases, that is title suit number 258/2022
258.
and 713/2023 to a single court.
One more title suit is also there.
No, that I have
Title
mentioned earlier.
17/03.
He submits that if the said transfer petition is allowed, then is allowed and the cases are, all the cases are tried by a single court, he may not have any objection on vacation of the stay granted by the impugn order on further proceeding of title suit number 713/2022. I have considered the submissions made by learned counsel for both sides. ... উপরও তো রাখিছে, no? Like, now I'll go through the judgment and I'm reserving it. I have dictated your submissions. Heard Mr. P. Khatuniar, parties are naam likhi. Hearing concluded, judgment reserved.
Intimate that my petition affidavit may be called for from the registry. My additional affidavit.
Additional affidavit to Mate. You wait for a few days. Next week. I'm not giving a fixed date. I'm reserving it.
It's up to lawsuit.
At the convenience of the court.
May not be there. Next week.
Your Lordship, due to some personal difficulty, my senior left the court. I take consent from the other side. Kindly adjourn the matter for today.
Heard, Miss, what is your name?
M.
M. Roy. Learned counsel for the
Respondent.
respondent who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. Mr. A.K. Gupta, learned counsel for the appellant, does not raise any objection. Hence, the prayer is allowed.
Chief, kindly fix it on Friday.
Mhm.
But only I pray for a date because this is an injunction matter, my lord. My injunction petition were rejected, my lord. So they may create the third party, right, my lord. That is the only problem.
What injunction?
My lord, I pray that only the third party right may not be created.
Friday is okay.
I'm
Okay on Friday.
Oblige you.
ready.
Please this matter on Friday is 12th.
Oblige.
Lordship, I am for the respondent. I need 4 weeks time to file objection.
In this matter, Lordship, the petitioner is the wife of the respondent, Lordship. I think he has approached the Honorable Learned District Judge for divorce of matrimonial for on ground of divorce, Lordship.
Your husband or wife? Wife. What is your submission to her prayer? Okay. Heard Mr. S.J. Sarkar, learned counsel for the petitioner. Also heard Miss, what is her name? Miss
B.S. Oja.
B.S. Ojha.
So why would we? Lordship?
Your name is?
Why would
Y. Barbuya. Petitioner's name is Y. Barbuya. Miss B.S. Ojha, who prays for some time, who prays for some time for allowing the respondent to file written objection against the prayer made by the petitioner for transfer of the, it is a divorce case,
Yes, your Lord.
transfer of the divorce suit. The prayer is not objected to by the learned counsel for the petitioner, hence same is allowed. Let this matter be listed after 4 weeks on a
It
date.
stays there, Lordship, till the returnable date, the matter was stayed. The next date is fixed on 20.
Stays there.
Yes, your Lordship.
Okay. After 4 weeks, the interim order of stay granted earlier shall continue till next day.
That's okay. Thank you.
Please, Lordship. Lordship, appeal under section 23 of Railway Claim Tribunal Act, Lordship, against judgment and order dated 27/8/25, passed by the Lordship, passed by the Railway Claim Tribunal, Guwahati branch.
Heard Miss P. Adhikari. What is her name? Heard Miss P. Adhikari, learned counsel for the appellant. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been filed by the appellants, namely Rimpi Day and Ridham Day, impugning the judgment dated 27/8/2025, passed by the Railway Claims Tribunal Guwahati bench in original application number OA dot Roman 2 capital U dash 18/2025, whereby the claim of the present appellant was dismissed. Issue notice to the respondent. You have taken steps. Issued notice.
First day, Lordship.
Issue notice to the respondent. No, you can serve notice on the standing council on this. You have
Filing.
issue notice to the respondent. Since the learned counsel for the appellant has submitted that the notice has already been served on the central government standing council, no formal notice need to be served on the respondent. The appeal is admitted. Call for the records from the Railway Claims Tribunal. A call for the records of the original application from the Railway Tribunal. List this matter after receipt of the records after 4 weeks.
Eight is your lordship. Your lordship, this appeal has been filed under section 23 of the railway.
What is your name?
Your lordship, A Deb, I'm on behalf of.
Heard Mr. A. Deb appearing on behalf of Mr. D. Rathi, learned counsel for the appellant. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been filed by the appellant Messrs. Mangal Murthy Vanijya, impugning the judgment and order dated 28/2025, passed by the Railway Claims Tribunal Guwahati bench in connection with the original application number OA within bracket Roman 3/GHY/008/2023. Stop. Issue notice. Stop. Since Miss, what is her name? R. Devi Learned CGC has appeared for both the respondents. No formal notice need to be issued. This appeal is admitted. Call for the records of the original application from the Railway Claims Tribunal Registry to take steps for requisitioning the records from the Railway Claims Tribunal. List this matter after 4 weeks on receipt of the records from the Railway Claims Tribunal.
21. Your lordship, similar prayer.
Same. Lordship.
Same order, only the number of original application will be different. Recorder plus logo. Same order.
Oblige. 22.
Eight page, your lordship. This is the regular second appeal, lordship. As a first appeal, lordship. In this case, my suit was dismissed as lordship barred by res judicata.
Barred by res judicata.
Yes. In fact, for both the prayers, your lordship will find it is not a barred by res judicata is because first suit was for right title, interest and recovery of possession by the respondent. And second suit filed by us, lordship. At the time of execution of that decree, they have damaged some house of the plaintiff's lordship. So second suit was filed praying for damages as well as recovery of excess land which was taken away during the execution.
Okay, we'll issue notice. Third, Mr.
I'm appearing for the component 7 and 8. My lord, what can be done? Because now the private parties has not appeared. That is very relevant in this case because res judicata is there. I had gone through the judgment, impugned judgment, and the finding seems to be correct of the lower court.
No, we'll examine.
So
Let,
what can be done? The private party let them appear and the records may be called. And after, if my lord is satisfied after seeing the record, only after admitting, after that admitting. And after hearing the private party. So that would be the best thing because
Saying that instead of admitting the regular first.
that may be done.
Lordship, that will.
We'll
be
not
better.
admit it. We'll
Yes,
issue
that will be
notice,
better.
call
Yeah.
for the records.
It can be
It can be decided whether to
Your
admit or
worship,
not.
and that may be good for them also because it will not get delayed. It may be disposed of at the
Yes,
admission stage.
yes. Heard Miss R. Chaudhary, learned counsel for the appellant. Also heard Mr. K.
Bhattacharya.
Bhattacharya, learned government advocate, appearing for respondent number,
7 and 8, the state of Assam response.
appearing for state respondent number 7 and 8. This appeal under section 96, read with order 41, rule 1 of the Code of Civil Procedure 1908, has been referred by the appellants impugning the judgment and decree dated 26/8/2025 passed by the Court of London Civil Judge Sri Bhumi, Civil Judge Senior Division Sri Bhumi in title suit number 13/2025, whereby the suit, where is the earlier suit?
Earlier suit, lordship, that is there.
There are
Lordship.
two, my lord.
Title suit, first one, lordship, annexure 1, page 17, title suit 3 of 2000.
Whereby Kile. Whereby the said suit was dismissed on the ground of res judicata in view of the judgment and decree passed in an earlier suit, that is title suit number 3/2000. Stop. Issue notice to the respondents, Since Mr. K. Bhattacharya has already appeared for respondent number 7 and 8, no formal notice need to be issued against the said respondents. As against other respondents, the appellant shall take steps for issuance of notice. Issuance of notice through speed post as well as through by usual mode within 7 days from the date of this order, returnable after 4 weeks. Also call for the record. Both the cases are disposed of.
Title suit 13 of the 2025 was dismissed as barred by res judicata on the basis of the judgment and decree passed in title suit 3 of 2000.
Where we will get that judgment? You have annexed here. Okay. Let the record of title suit number 13/2025 be called. No, that record we are not calling. That record is somebody else's suit. That suit was filed by whom?
Contested. It's defendant. Written after filing written statement, we did not appear. in
What
that.
is the status of that suit?
That suit is
Execution.
Executed.
Executed.
Yes, but
Let the records of title suit number 13/2025, as well as title suit number 3/2000 be called for from the court of London Civil Judge, Senior Division Sri Bhumi, and London Civil Judge, Junior Division Karimganj, respectively.
Civil Judge Junior Division number 1.
Number 1 Karimganj, respectively. Let this matter be listed again in the admission column after receipt of the said records. List recording.
The month of January or February.
Notices will be returnable by how many weeks?
4 weeks.
In the month of January or
In
February.
any case, it will
date
come
of-
after 4 weeks.
No, after 4 weeks, if it does not get listed, you may mention.
No,
Obliged.
because the 2000 case, they will take some time to search it out,
Yes.
as my experience goes.
Obliged, Lord.
Yes, yes.
Yeah, please, Your Lordship. Lordship, in this case, by the earlier order, only notice was issued, records of the case was not called for. That may be called for, and Lordship can fix another date for admission hearing. Okay, Lordship.
What is your name?
Ardwara.
Heard Mr. R. Dwara, learned counsel for the petitioner. Also heard Mr. P. K. Kolita, learned counsel for one respondent only, learned counsel for the respondent. It is submitted at bar that though by order dated 6/8/2025, notices were issued, however, records of the trial courts were not called for. What you are impugning? What is the impugn order?
Impugn order dated
Whether records would be necessary? Why?
2025.
Where is the impugn order?
Annexure A.
Page number? Oh, it is a judgment.
Judgment. Whereby misappeal was dismissed. I'll by the petition.
Lordship, here the suit has arisen out of a agreement. And this is a specific performance suit. And the suit, I have filed a suit on the basis of an agreement and on the schedule of the suit land. It is not specific because only the DUG number, patta number is available there, but no boundary is there. On that pretext,
Suit was dismissed.
suit was not, only order 13, rule 1 and 2 petition has been dismissed. And suit is continuing and it is in the evidence stage. So after dismissing their injunction applications by the learned trial court below, they have preferred an appeal before the civil judge, Amingaon, senior division. And that was also dismissed. And they have come
Against that dismissal order,
now against that impugn order, they have come.
what ground?
Lordship, there was an two agreements. One for the suit.
No. Revision.
Revision. Yes.
This is a revision.
Yes, Lordship, I'm saying.
Oh, okay, we are calling for the records.
Scan copy.
Yeah, last,
Scan copy.
it is also submitted at bar that perusal of the records may be necessary for disposal of the, for consideration of the instant civil division petition. So considering the submissions made by learned counsel for both the sides, let the scanned copy of the records of misappeal number 7/2022, as well as misappeal number 2022 be called for from the Court of Learned, Civil Judge Senior Division, Kamrup, Amingaon. Registry to take steps for requisitioning the records. This matter after receipt of the records.
Lordship.
24.
Make me this model. Well, this is a landlord tenant dispute matter. The respondent herein is the landlord and I am the tenant. And they filed a suit for eviction on the ground of recovery of area rents and bona fide requirement. Initially, the suit was decreed on both the grounds, my lord, for defaulter as well as bona fide requirement. Thereafter, we preferred an appeal. In the appeal, the ground of bona fide requirement that was reversed. And only on the ground of defaulter that I failed to pay the rent. I could not prove the payment of rent from the month of November 2006 to June 2007. Only on that point, it was, my lord, the appeal was dismissed. So against that, we have preferred the present revision.
What is the status of any execution case?
Execution.
My lord, execution case we have filed.
Not filed.
Not
Then we let us admit this.
concurrent pending.
The records is necessary, my lord.
Record would be necessary.
File the evidence and all, but the documents have not been filed.
My lord,
I rely upon certain documents. my lord.
my lord, whatsoever is there in the record, we have already brought to the notice of this honorable court by way of filing an
The
affidavit.
documents are not there. They have filed the cross-examination part and the evidence on affidavit.
No, but revision is limited. We cannot go into evidence in detail.
Because why I'm saying, my lord, record, only because exhibit A1 to A42, the court has held that, my lord, there was a loan amount which they had to repay me. That is, the landlord had to repay to the tenant, my lord. And that was adjusted by paying 18,000 per month by them from the month of, my lord, May 2003 onwards. I have seen my records, my lord. I have not found, only for 6-7 months they have adjusted that amount. But for the other months, my lord, I have not come across. That's why I thought, my lord, the records, if records come, my lord, then it can be verified and corroborated also.
Let us call for the record.
Let us call for the record on the date of admission itself, my lord, if the honorable court.
Heard Mr. A. Iqbal, learned counsel for the petitioner, also Mr. A. Sattar, learned counsel for the respondents. How many respondents are there? Respond, sole.
Four.
For all respondents. It is submitted by learned counsel for the petitioner that though notices were issued in this civil revision petition, however, records of the first appellate court as well as of the trial court were not called for, which according to him would be may be necessary for consideration of the instant civil revision petition. Stop. Learned counsel for the petitioner considered
Respondent, my lord.
respondent
Considered.
also conceded to the said prayer. Hence the prayer is allowed. Let the records of which cases?
Yes, 201/90, 201/7, my lord, and title appeal 28/23, my lord.
Title suit number 201/2007 be called for from the Court of London, Civil Judge, Senior Division number 1, Kamrup Metro at Guwahati, as well as the records of title appeal number 28/2023 be called for from the Court of London, District Judge, Kamrup Metro, Guwahati. The registry to take steps for requisitioning the aforesaid record. List this matter again in the admission column after receipt of the aforesaid records.
My lord, there is an IA also, which we have preferred, my lord, under order 39.
They have not filed any execution.
Not for execution, my lord. What has happened, my lord, after the dismissal of the appeal, they have disconnected the electricity supply. Since the month of June, my lord, 2025,
file
I
the
am
objection,
running
my
my
lord.
business, my lord,
If
without
the
any
IA, I will file the objection.
because there won't be any prejudice if the electricity is restored. My lord. I am running my business since July, my lord, without any electricity.
IA copy is submitted to me. I will file the objection to that, my lord. How far he is telling truth.
because
that
there is no scope for telling any lie, my lord. Why would I tell lie?
Is an application and the order that
Para 5, my lord.
I will file the objection, my lord.
Second week of July, I'm running my business without electricity, my lord. I'm running through generators, my lord. That is in- incurring huge expenses.
When will you file objection?
Within this month, my lord. Before the vacation
I had
starts.
filed this application in the month of July, my lord. They had got ample opportunity to file.
But copy you have given to the.
Then why it is coming up for hearing now? It has come up for the first time.
Not for the first time, but no order was passed while issuing notice.
Okay, now we'll issue notice. Heard Mr. A. Iqbal, learned counsel for the petitioner. This interlocutory application has been filed by the petitioner in connection with CRP number 113/2025 under order 39 rule 1 and 2, read with section 151 of the Code of Civil Procedure 1908 for grant of mandatory temporary injunction for restoration of electricity connection to the suit premises. Learned counsel for the respondents has submitted that he needs some time to take instruction in this matter and if required to file a written objection against the prayer made in this interlocutory application. The prayer is allowed. Let this matter be. When can we fix it?
January.
6th of January. Let this matter be listed again on 6th of January. Before the said date, the respondent side may file written objection if they desire to do so. List accordingly.
Under order 41, item 26.
Yes.
Yes, may I please lordship? Lordship, this RSA is against reverse finding. The respondent number 1 filed the title suit, lordship, seeking declaration of right title interest and recovery of position. That suit was dismissed by the learned trial court, lordship. Thereafter, they preferred an appeal, title appeal, and that appeal was allowed, lordship. Thereafter, the honorable court already issued notice.
What was the prayer? The relief which was prayed for in the title suit? Suit was for?
It was for declaration of right title interest and recovery of position, lordship. At the prayer portion is at page
The
21, lordship.
appellate court
Lordship.
reversed the decree of dismissal.
Yes, sir.
Okay. Now, what are the substantial question of law which?
Substantial questions of laws are at page 12, lordship. Lordship, though I submitted 6 substantial question of law, lordship, but I don't want to press substantial question of law number 1.
Yes.
Lordship, what happened, the respondent prior to this suit, Lordship, filed another title suit. And that suit was dismissed, Lordship. Thereafter, they filed an title appeal, Lordship, that was also dismissed, Lordship. Thereafter,
That suit was suit. That is suit number. And your suit,
title suit number, Lordship, the former suit, Lordship,
former suit.
10/2011, Lordship.
In respect of the same property,
Yes, Lordship.
same relief.
Same schedule, same relief.
Okay.
Not same relief, that was for specific performance of contract, Lordship. And here in this case, they have sought declaration of right title interest.
Right title in interest on what basis?
On telling that he is joint owner of the suit land. Actually, what happened, Lordship, a Schedule A land was purchased by both the appellant and father of the respondent, father of the appellant, Lordship. Hereafter, due to some verbal family arrangement, the whole Schedule A land was possessed by the appellant, Lordship.
Who is appellant?
I am for the appellant, Lordship.
And who is respondent?
Respondent for
My lord, I am a.
What, is there any relationship between?
Lord, my lord,
uncle and nephew, Lordship.
my
Okay.
lord, we have filed our account number on behalf of my lord, respondent number 1, my lord. And my lord, in this matter, my lord, LCR required, my lord.
No, suit is yet to be admitted. Substantial question, if there is no substantial question of law, then the second appeal will be closed at this stage itself. Records would be required if it is admitted. It may not be admitted. You appeared on your own whether or notices were issued.
Lord, by the notice, my lord.
Notice were issued without formulating substantial question of
Yes,
law.
Lordship. Yes, Lordship. On that day, actually, the Honorable Court was very busy, Lordship. And due to paucity of time, the Honorable Court issued notice, but granted stay, my stay prior, Lordship, on that day. But as there was as many as 6 substantial question of law, so Honorable Court could not give time to discuss all the substantial questions of law, Lordship. Lordship, what happened, Lordship? I was on the basis of a verbal family arrangement, Lordship. I was possessing all the suit land, Lordship, and that has not been partitioned. Even after not being partitioned, Lordship, the respondent.
Who was the original owner of the suit land?
Original owner is suit land is some. He's not
No,
party
no,
in
what
this.
is your basis? Inheritance,
No, Lordship, jointly purchased, not inherited.
jointly
Jointly
purchased.
purchased.
Okay, okay,
My father and the respondent number 1 jointly purchased the suit land.
okay.
Both were actually my father and the respondent were brothers. Thereafter, due to some verbal family arrangement, he was possessing some other lands, and instead of that, I was possessing the whole land. Thereafter, somehow they took a signature on a blank stamp paper, Lordship. And thereafter, they claimed that we have entered into an agreement for sale with the respondent, Lordship. And thereafter, they filed an suit for specific performance of contract, so that their allegation is that we have given 500 rupees to him out of the total consideration amount. Total consideration amount is 1,15,000, Lordship, and they were asking the remaining 1,14,500 from me and to enter the register sale deed. Whereas we had not entered into any agreement for sale, Lordship. And thereafter, they in their suit
stated that they were possessing the Schedule B land, which is a part of Schedule A land. But during cross-examination, Lordship, if your Lordship come to page the judgment of
No, according to family arrangement, you were possessing entire Schedule A land.
Schedule
How much is the area?
A. Area is Lordship. ছয় বিঘা 2 কঠা 11 লেছাল আছে।
6. And in respect of which land the agreement to sell was made?
50% of the aforesaid land Lordship, which has been mentioned as Schedule B land, 3 বিঘা 1 কঠা 5.5 লেছাল হচ্ছে।
Schedule B land. Okay. Then what happened?
Hereafter, they filed entitled suit Lordship.
For specific performance of contract.
That suit was dismissed Lordship.
That is 10/2022.
Yes, Lordship.
Okay.
That is, Lordship, that is. That is 10/2011 Lordship. Hereafter,
2011.
title suit number 10/2011 Lordship.
When it was dismissed?
It was dismissed on 1/8/2015 Lordship. I have annexed the judgment of that.
Okay, thereafter what happened?
Thereafter, they preferred a title appeal Lordship.
Title appeal number?
Title appeal number 23/2015 Lordship.
Thereafter?
That title appeal was also dismissed Lordship. Height order dated 27/1/2017.
Thereafter?
Thereafter, they did not prefer any regular second appeal or revision, etc. Lordship.
Okay.
Thereafter, they filed another title suit.
This title suit is?
This title suit is Lordship, title suit number 2/2023.
For declaration of right title and interest
Declaration of right title interest and
and
recovery
recovery
of
of possession.
Yes, Lord.
Okay.
In the first suit, in that suit also they prayed for recovery of possession Lordship. Though the suit was specific performance of contract,
Okay.
with that prayer, there is a prayer of praying for recovery of possession by the respondent number 1 Lordship. After this suit was dismissed Lordship, the title suit number 2/2023.
This was also dismissed.
Dismissed
By order dated?
by order dated 14 March 2024 Lordship.
Thereafter title appeal.
Hereafter, they preferred a title appeal being number Lordship 4/2024.
What happened to it?
The
They
title appeal.
reversed the
Reversed the judgment.
and
passed by the
decreed in
court.
their favor.
Yes, Lord.
Okay. Now,
Lordship, if your Lordship kindly goes to the judgment and
now what substantial question of law?
substantial question of law is Lordship. At Lordship is number 12 Lordship. Number 1.
One is you are not pressing.
Yes, Lordship.
Then
Number 2 is Lordship, whether plaintiff/respondent can sue for declaration of right title and interest afterward in the suit without seeking leave of the honorable court, whereas the respondent plaintiff could have sued for declaration of right title and interest in the former suit.
how he can?
Lordship, as per order to rule 3 Lordship,
Order?
order to rule 3 Lordship of CPC,
Yes.
so Lordship, order to rule 2 sub rule 3 Lordship.
Yes. What you want to emphasize?
Lordship, my submission is that in the earlier suit,
they could have prayed for declaration of right title interest.
How they can pray for declaration of right title? That was for the specific performance of contract. The agreement was not even executed. Their prayer was for execution of the sale deed. On what basis they will claim right title in
Yes,
interest?
because their title was clouded, Lordship.
No, there was no title. Their prayer was for specific performance of agreement to sale. So they could not have prayed for declaration of right title in interest. This substantial question goes, it is not there.
I am maybe allowed to raise another substantial question of Lordship. Question number Roman 4, Lordship.
Yes.
Whether the respondent plaintiff claiming himself to be a co-owner of Schedule A land can seek right title interest and recovery of possession of a specific portion of other Schedule A land, that is the suit land, with his choice without seeking for partition of the Schedule A land. Suit A land is jointly owned by both the plaintiff and respondent. That was not partitioned, Lordship. But he is praying for a specific portion where 2 mobile towers are there, 1 rice mills are there, Lordship. So, seeking partition of the suit land, how can they?
No,
seek-
on what basis the appellate court decreed the suit?
Lordship,
What was the reasoning?
reasoning is, Lordship, learned appellate court, first appellate court, Lordship, failed to consider the admission of the respondent during his cross-examination, Lordship. If your Lordship kindly goes to page 38, Lordship, the judgment and decree passed by the learned trial court, Lordship. Page 38, Lordship.
Yes.
Paragraph number 32, Lordship. However, in cross-examination, PW1, that is the respondent number 1, Lordship, has contradicted his own plea and admitted that the scheduled land is not partitioned. And it is still under the long position of both the parties, and also that the defendant has been possessing the same, defendant means, Lordship, the present appellant, possessing the same since 1972 by installing a rice mill. Hence, the admission of the plaintiff goes to show that the suit land was not under his possession, as claimed by him in the plaint. Rather, it is proved by his admission that the scheduled land has been occupied by the father of the defendant immediately after the purchase. The learned first appellate court, Lordship, did not consider the cross-examination part of the respondent, Lordship, and wrongly took a view that the suit land was partitioned and he was in possession.
No, where is the observation that it was partitioned?
The learned first appellate court made the observation, Lordship.
Where?
Lordship, at page 64, Lordship. On the basis, paragraph number 38, Lordship.
Yes.
On the basis of the aforesaid discussion, it is found that appellant plaintiff has able to prove that after purchase of Schedule A land jointly by appellant public plaintiff and father of the respondent defendant number 1, it is amicably partitioned between the two, and the suit be property fell into the share of the appellant plaintiff. Lordship, the plaintiff himself admitted during his cross-examination that the Schedule A land was not partitioned, and that is still under the, it was under the position of initially by my father, and now I have been possessing the overall schedule A land lordship. So lordship, without partition of the schedule A land, how the respondent number 1 can claim a recovery of possession of a specific portion of land as per his choice lordship?
Yes,
Yes, my
anything.
lord, appellate court has rightly passed the judgment. My lord, that at page 50. my
Whether
lord.
any execution case has been filed?
Yes, yes, my execution case, my lord. Title execution number 6/2025, my lord, and it was an order was passed, my lord.
Execution, unfortunately, lordship, prior, the execution case was completed. Execution was completed, lordship. To that
Execution is
extent, lordship,
over.
recovery of possession was given to them,
Yes, my
but they have taken the position of the suit land, lordship.
It is now in their possession.
in
yes,
their
my lord.
position.
At present,
Okay.
degraded land is our possession, my lord.
Position.
Okay, we'll formulate one substantial question of law
Yes.
and issue notice.
Notice already issued, lordship.
Okay. Heard Mr. U.B. Sharma, learned counsel for the appellant. Also heard Mr. What is your name?
E.K. Roy.
D.K. Roy, learned counsel appearing for
Respondent 1.
respondent number 1, as well as Mr. F. Faridi, appearing appearing for respondent number 2 and 3. What happened to 2?
Lordship, actually, as per office note, lordship, their address is not correct, lordship. They have, most probably they have shifted their office, lordship. And he was pro forma in the title suit also.
Yes.
No claim was against him, lordship.
No, respondent number 2. Stop. After considering the submissions made by learned counsel for the petitioner as well as learned counsel for the respondent who are present before the court, following substantial question of law is formulated in this case. Whether the first appellate court, while reversing the judgment and decree of the trial court, acted perversely in holding that the suit land, that is,
Schedule B land, lordship.
that is the Schedule A land has been amicably partitioned in 2 halves and holding that Schedule B property fell in the share of the present respondent number 1 without there being any evidence to that effect on record. issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. The other respondents are duly represented by their engaged counsel. Let also the records of the trial court as well as first appellate court be called for. The registry to issue a requisition for the registry to take steps for requisitioning the aforesaid records. List the matter after 4 weeks on receipt of the records.
Highly obliged, Lordship.
Item 14.
May I please the Lord?
This I is for
IA two IAs here, my lord. One is for delay and another for after passing of the judgment in appeal, eviction notice has already been served recently. That is 25th of December, giving 15 days time to vacate this premises. And it is expiring today. So two
you
IAs
vacate
here.
it.
My lord, the fact is that my mother, petitioner, his mother is the pattadar here. But with the design to evict them, the ONGC authority has served a notice in the name of his her elder son, that is the petitioner. Petitioner is not the pattadar here, he is the family member. So it is a.
No, first let us
My lord.
decide your delay condemnation. How much delay is there?
Delay is, my lord, 190 days. Impugn judgment was passed on.
Are you
28th.
opposing?
Yes, Lordship. We have to file objection. In some cases, there was analogous, that is the 10 cases. Order has been passed with the additional district judge, Sibsagar. They filed writ petition on the advice of the court that it should file CRP instead of filing the WPC. So some cases they have filed, we have received a copy, we have filed earlier.
Therefore, delay was caused.
Previously, most probably those are
Okay,
also.
we'll issue notice in delay application. Heard,
That's it also.
Mr. A.C. Das, learned counsel for the applicant. Also heard Mr. J. Das,
He does, Lord.
E. Das, learned
For
counsel,
all respondents.
counsel appearing for all respondents. This application under section 5 of the Limitation Act 1963 has been filed by the applicant praying for condoning the delay of 190 days in preferring the connected civil division petition. Since Mr. T. Das has appeared for all the respondents, no requirement of issuing formal notice to the respondent is there. Stop. However, learned counsel for the respondent has submitted that he would be filing a written objection against the prayer for condoning the delay, and some time is prayed for the same. The prayer is allowed. Let this matter be listed in the second week of January 2026.
Madam,
Other I,
Madam, until that next day, no coercive action will be taken because already notice has been served. Other IA is there pending. Actually, no, next day.
another I is
That is eviction need to notice aftermath of passing of the impugn judgment.
why this I has not been numbered.
There is in Cosby list, it is shown as filing number.
No, this I has to be numbered.
May submit lordship. Actually, on the basis of the first eviction notice, they preferred the mixed appeal in the, before the learned, that is Court of Additional District Judge Shivsagar. After long gap, we have issued the second notice. Without going to the, again, additional district judge, they have directly filed the page before this honorable court for STADA, that is the eviction notice, which has been issued by ONGC. So they have to prefer mixed appeal again, because first notice has the judgment has been delivered. We have issued another notice, second notice. They are coming before the lordship.
Okay, you filed the.
Second eviction notice.
it would
They have not taken any
be-
steps on second eviction notice.
But the thing is that, my lord,
Till next returnable date. We are staying till that date. You
Yes.
file the objection.
Objection will file in both the cases with objection. Actually, because first the limitation has to be overloaded. That's why probably the number has been not been made by the.
No, we are not passing order in that case. In this case itself, we are staying the.
Hello.
Which notice?
that is it is page 80, that IA and H 2. It is 25th of 11 November, it is 2025.
Where is that notice?
That IA, my lord, which is not numbered as filing serial number is there.
Okay.
That IA. It is page 18. And H 2.
Learned counsel for the petitioner. Next, learned counsel for the petitioner has submitted that the petitioner has also filed another interlocutory application for staying the operation of the impugned eviction notice dated and bearing memo number AA/NZR/estate/eviction-DS-GLK #84/2025/9 dated 25/11/2025. However, he submits that said interlocutory application is not yet registered as the delay condonation application is yet to be decided. He submits that in the said eviction notice, the petitioner has been given time till today to vacate what?
Premises as their own term, it is premises. Public premises in their terms. Public premises.
It is land or what?
This plot under unauthorized occupation.
Vacate the land described in the said eviction notice. He submits that unless
There is no schedule.
the said eviction notice is stayed till next returnable date in the delay condonation application itself, the petitioner would be suffering or would be highly prejudiced. Considering the submissions made by learned counsel for the petitioner till the date of filing of the written objection by the respondent authorities, and till disposal of the instant interlocutory application for condonation of delay, the operation of the aforesaid impugned eviction notice shall remain stayed.
Lordship, may please, I would like to inform one thing, Lordship. First eviction notice we have.
No, I have understood.
Well, Lordship.
That has been decided.
That has been decided, that is in force, Lordship. That has been affirmed by the additional district judge Shivsagar. That is in force now. Lordship.
So in view, in
Because
on the strength of that notice, you can evict him.
no. Maybe coercive action may not be taken by Wednesday, I do not know. But one thing is that is in force, Lordship, already.
Okay, that we will decide in the CRP.
That will be decided in the
In the CRP.
Just
Provided the delay is condoned.
they'll delay it from there. Obliged. Obliged.
Please, your lords.
Oh. Time is over. Yes.
He's taking time anyway.
Your lords.
He's not doing.
Your lordship, this engaged senior counsel is not present today. He could not be present due to.
What is your name?
Emma Talukdar.
Heard Mr. M.R. Talukdar, learned counsel for the appellant. Also heard Mr. K.K. Bhattacharya,
Appearing for pro forma respondent, state of Assam party.
appearing for the state
13 to
respondent,
26, 16.
state respondent. Learned counsel for the appellant has prayed for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is not opposed to by the learned government advocate. Hence, same is allowed. Let this matter be listed when
As per the court decides.
Well, new way after being.
after Bihu vacation.
Bless you.
Anything?
I have one matter, regular first appeal. I'm the appellant. It is item number 32. So.
Today we are short of
also
time.
apply.
So it will be listed, shown as leftover, listed accordingly.
Number 30, service is complete, your lordship.
I'm appearing for respondent number 1.
Substantial question of law has been formulated.
But this is RFA, your lordship. Regular first appeal. And the service is complete, it will go for admission.
It will go for hearing.
Hearing, your lordship.
Okay. Show the presence of both the sides. The appearance of parties is complete in this case, hence this case is ready for hearing. The records of the trial court
It has been received, your lordship.
has
It
been
is
received. Hence this case is ready for hearing. Liz,
Can it be
this may-
28-1, your lordship? Here the arguing counsel is from Tinsukia, your lordship.
no. Liz, this matter for hearing after Bihu vacation.
After Bihu, 28.
No specific date.
Deeply obliged.